For the Board of Zoning Appeals meeting of November 17th, 2022. This time I'd like to ask everyone to please either silence or turn off your cell phones. My name is Elizabeth Waits. I'm a member of the Codes Department staff, and I'll be introducing the cases on public hearing today by presenting the board with maps, photos, and proposed site plans for each of the subject properties. The information I present, as well as the applications, recommendations, and other government agencies, and any letters that we've received from the public, either in support or in opposition to each of these applications before the board today, have been provided to the board members to review in advance of today's meeting. Okay, sorry, I'm trying to change the order of how we're doing a couple of things. So let me see. I don't know that we have any council members present. I didn't see any. Just wanted to make a note of that. I don't believe so. So here in just a few moments, we're going to start calling through today's agenda, at which time we will hold the matters that are on public hearing, and then there may be some items that we ask the board to review prior to the public hearings beginning. I will explain that a little bit more in detail momentarily. For contested matters that the board is going to hear today, applicants will have 10 minutes to make their presentation to the board. We want to make sure that all applicants are aware that the 10 minutes that you have to make your presentation will be 10 minutes to include everyone that you would like to speak in support of your request. So if there's anyone here with you today who is also planning on speaking in support of your request, then you would all together have 10 minutes to make that presentation. Then anyone who is not in favor of the request will also have a combined 10 minutes to speak, and you would have an opportunity after hearing from the opposition testimony to make a rebuttal. So please note that if you want to make a rebuttal to the comments that you're going to hear in the opposition, that you'll need to reserve some of the 10 minutes that we allot to you for your rebuttal. Usually people like to reserve around 2 or 3 minutes, so please go ahead and make that preference known whenever you're making your presentation. You'll also need to turn the microphone on at the table when you come up here, and then you'll push a button that looks like a little person, and your microphone will turn red, and that's when you know that you're ready to speak. You will state your name and your address to the board before making your presentation. The Metropolitan Code requires 4 votes to grant an application. And once a vote is taken on your application, a party who disagrees with the outcome may request a rehearing within 40 days. Parties may also appeal a decision to the Davidson County Chancery Court by filing a writ of certiorari within 60 days. All parties are encouraged to seek independent legal counsel before filing an appeal to ensure that all deadlines and procedures are followed. For all applications that are granted today, the applicant will have 2 years to complete the building permit for which you have applied. I believe that we might just take a quick. All right, thank you. At this time, I'll be reading through the items that will be proposed for the consent agenda to the board. These are items that have been reviewed by the board chair, and if any member wishes to hear one of these items rather than approve it on consent, then please let us know at this time as I go through the items that we are proposing. We have 4 matters that are proposed for consent. Those items are case number 2022-144. This is a request for an additional monument sign at 100 Centerview Drive, zoned OL Office Limited. Case, let me see, is there anyone here wishing to speak against that proposal? I don't believe so. Case 2022-146 is a request for a variance from the side setback requirements to permit an existing fence at 2707 Natchez Trace, zoned RS 7.5. Is anyone here regarding the property on Natchez Trace? Are you the applicant? Okay, and no one's here in opposition. All right, thank you. Case number 2022-147. This is a request for a special exception to allow an addition to an existing church at 901 Acklen Avenue, zoned RA 8, is there anyone here to speak in opposition to the request for an addition at 901 Acklen?
Are you?
Okay.
Did you raise your hand? I did, yeah. Okay.
Yes, you're wishing to.
Against that?
Yes.
I'm sorry?
You're here to speak against that application?
Possibly, but we're here goes on.
I'm sorry, I couldn't hear you.
Possibly.
Okay, all right, we'll take that off. Okay, we'll take that off.
Okay, so that one will be removed from our list. And then the last item on our proposed list is going to be 2022-150. This is a request to permit an enclosure of an existing, reminder about the phones, please, an existing deck for property located at 5161. You must be the applicant on this, 5161 Bay Overlook Drive.
No.
Okay.
I'm here for the one that is the 144.
Okay.
I think that you did.
Okay, I'll come right back to you. Case 2022-150 is a request to permit enclosure of an existing deck for property located at 5161 Bay Overlook Drive in the RS15 zoning district. Is anyone here to speak against that request? Okay, I do not see anyone. And ma'am, you were asking about the property on which address?
144. The one about the sign on Commerce Drive.
Yes, it's a sign on Centerview.
Centerview Drive. Okay.
Centerview Drive.
Okay.
Are you here to speak in opposition to that? Okay. So, Mr. Chair, thank you. Okay, so that leaves two items that are for the proposed consent agenda, and I'm just going to review those again really quickly. We'll be asking the board to approve the fence at Natchez Trace. That's case 2022-146. And as well as the deck enclosure at 5161 Bay Overlook Drive. That's case 2022-150.
Make a motion that we approve the consent agenda.
I'll second it.
Okay, all in favor of approving the consent agenda, raise your hand. Any against? None. That passes 4-0, so those two go on the consent agenda.
Okay. Okay. Thank you. We're just making a few administrative changes really quickly. Hi, Ann, is that you?
Yes, I'm here.
Okay, great. Thank you so much. I'm going to just leave you here on the phone, but I know that you can hear me on the live stream, so thanks. All right. First case on the board's public hearing docket today, case 2022-110. This is a request for a variance from the side setback requirements to construct a rear carport at 1601 Shackleford Road in the R10 zoning district. Before you here is the copy of the zoning map for this area, an aerial view, the front of the home. The structure in question is to the rear of the home, so this is a sort of blown-up aerial view to help see how the property backs up to the neighboring parcel. And then below, there's a photo of the subject structure to the left, and then there's the sort of the side of the neighboring home there as well. You can see where their property lines abut. Some additional photos of the portion of the structure that exists today. And this is the site plan that was submitted by the applicant. It's the applicant present, and was anyone else wishing to speak?
The applicant here for?
I see. Okay, thank you. It appears that the gentleman unfortunately went to the wrong location, probably wasn't aware of the location changed locally. He's gotten in touch with us. He's been given the proper information. And so if we could just push that one to the rear of the docket.
I think there are probably a lot of neighbors. I get the sense there are other people here to speak against it. Can we just roll it one that way? They're not waiting around.
Yes, thank you, Mr. Chair. We'll be happy to let the board know as soon as the applicant has arrived.
Okay.
And then the next case 2022-136, this is a request for a variance from the minimum lot coverage requirements to allow construction of a two-family development at 4801 Michigan. The applicant on this one also contacted us to let us know that he actually has gotten tied up in a court proceeding that he thought would be concluded by now. And he does expect to be here if possible. And so he has asked to roll that one to the end of the docket if we can. So then next we have case 2022-138. This is a request for a variance from the minimum area to permit an existing detached accessory structure at 3253 Lakeshore Drive, zoned RS20. Here's the copy of the zoning map as well as the aerial views. This is the front of the lot and the structure in question, as well as the site plan that's been submitted by the applicant. And the applicant for this case, Lakeshore Drive, okay, if you'd please come forward, push the button for the microphone to turn it on. Yes, this seat here, yes. Okay, and then if you'll state your name and address before you get started, you have 10 minutes. Oh, I should ask if anyone's here in opposition. We've received some communication. Okay, thank you.
Which button? To the right or left? It was a little person. Okay, great. Thank you. Going first is never fun, so please bear with me. Mr. Campbell, who is the property owner.
Can you state your name and address?
Oh, I'm sorry.
Please,
Yeah, I was going to. My name is Theresa Agee. I'm representing Daniel Campbell, just a friend of the family. Mr. Campbell works for United Parcel Service and is a long-haul driver, and he's out of state during the week, so he was not able to come. Just a little background, if we could. Mr. Campbell purchased the home at 3253 Lakeshore Drive in March of 2020, right at the beginning of COVID. The home backs up to a commercial strip mall. That mall contains a liquor store on the end closer to Mr. Campbell's home. There's a salon next door, and it also runs parallel to Old Hickory Boulevard, so quite a bit of traffic through there. Again, his job requires him to be out of state during the week. Soon after he moved in, he began to notice that his personal property was being stolen. He had quite a few toys and stuff, as most men do. He began to notice tools, car parts, trailer parts and wheels missing. Windows were broken out of cars that were on his property. He also had personal property sitting in the yard and rusting, basically. The property did contain a one-car garage, and that's where Mr. Campbell parked his car. So basically, there was no room for any other personal property. The neighborhood around Lakeshore Drive has no HOA. There are a lot of large storage buildings built behind small homes. There are also houses built behind other houses. I've got photos of some of those neighbors' properties. I would love to pass those around if I could. I don't know if I need to approach or how this works, but okay. The addresses are written on the back of the photos. Again, he noticed that there were large storage buildings in the neighborhood and decided he needed something similar to protect his property. He and a friend purchased the kit for a storage building. After trying to reach the codes department with no luck, again, this was during COVID, Mr. Campbell had a survey completed. That survey is attached and also is obviously shown up here. So he proceeded to build a storage building. He built the building to match the garage and the home. It's very aesthetically pleasing. He later had a concrete floor added and set gravel around it so that he could connect the building to his driveway. He also had NES come and install a street light for extra security. During this time, Mr. Campbell had still heard nothing from codes, again, at the height of COVID. Mr. Campbell has spoken with several neighbors, and there's only one that has submitted an issue regarding the building. He's here today, and I'd like to address that after he speaks. He also sent out over 111 letters to his neighbors, placed a sign in his yard, as was required, that notified them of this meeting. He's received no response to the letters or the signs other than the one neighbor that will be here and speak. Mr. Campbell's requesting approval of this, of his appeal for variance for the following reasons. The closeness of the property to Old Hickory Boulevard, a strip mall with the liquor store, the salon next door. It increases traffic and makes this sort of a unique property in our opinion. The specific conditions cited are unique to this property. They generally are not prevalent to other properties in the general area. The strip mall is contained and only behind basically his house and one other home, which is the next door neighbor. The alleged difficulty or hardship has not been created by Mr. Campbell. He had no idea when he moved in the neighborhood that his things would be stolen or that this would not be a safe place. He used to live across the street and had his home broken into when he lived over there, and it took 7 hours for the Metro Police to arrive. So he didn't have a lot of confidence in the police at this point. There's no financial gain involved. It's not a basis for the appeal. All he's doing is storing his motorcycle, trailers. He's working on an old Mustang, and that's what's in the garage. The granting of the variance will not be injurious to other property or improvements in the area. It won't impair supply of light or air, and it doesn't diminish or impair any property values within the area. In fact, it seemed to increase the property value for his house specifically. And again, other properties have these large storage buildings as well, very close to him, right down the street. The granting of the variance will not be detrimental to the public welfare, will not substantially impair the intent and purpose of the zoning code. And just as a final reminder, Mr. Campbell's neighborhood does not have an integral master development plan. Mr. Campbell has already applied for a self-permit. He agrees to pay any fines incurred pursuant to this appeal, but he would very much like to keep his storage building. And again, I'd like to save just a few minutes to speak after the neighbor speaks.
You have some time left for rebuttal.
Okay.
At least a couple minutes, I would think.
Okay.
There may be some board members
Questions?
that have questions for you.
Yep. Have you been inside the structure?
I have.
You've observed it?
I have.
Okay.
It's very nice. It's got a concrete floor. It only has tools, what I stated earlier, in it.
Is there plumbing in the structure?
No.
Are there any beds or bedrooms?
No.
Okay.
No. Simply storage items.
Do you know why he didn't get a permit before he built this?
Well, again, it was during COVID. He tried calling. Of course, he's out of state all week. So he did try calling, try to, set up an appointment or talk with someone. He just couldn't get in touch with anyone.
At Metro?
Right. Mm-hmm.
And this may be, you may be able to answer this, or maybe for the zoning representative to do this, but I'm assuming that the issue here is the allowable area of the structure. Mm-hmm. Why exactly does the structure need to exceed the allowable area that's provided under the code? Because you can build a structure, why does it need to exceed the allowable area?
It was really a misunderstanding of the regulations, I think. He thought his home is about 2,500, 2,600. He thought that it was the half of the footprint of the home, not just the footprint of the bottom part of the home. So that's why he built larger than he should have.
Do you know what the footprint of the actual home is?
The home is around 2,600. It's 6 bedrooms.
Right, but the footprint of the home,
the footprint of the home itself? I don't know.
Okay. Would it be safe to assume that it would be around, if it was half of 2,600, would it be around 1,300 square feet footprint?
That would be a safe assumption,
Okay.
I would think, yes.
Okay, thanks.
Mm-hmm.
Okay, ma'am. Thank you. You have some time left on rebuttal.
Okay,
and
thank
the
you.
question time did not count against your time.
Okay, thank you very much.
Okay. Anyone in opposition may come forward, and please state your name and address for the board.
Sure. My name is Justin Amaral.
If you could make sure, if you could wait till you're in front, or you can sit right there, but just turn the red. There you go. If you can.
Thank you. My name is Justin Amaral.
And what's your address, sir?
My address is 2175 Neely's Bend Road in Madison.
All right.
My wife and I are the owners of 3832 Old Hickory Boulevard, which is the if you're looking at that survey, it's the bottom left-hand parcel with the garage encroachment. And just a point of clarification, the pictures that were shown before with the garage in question was not pictured. So I think they showed a picture of the house with a garage, which is not on that survey. There's the picture of the front of the house with the garage to the left is not the garage we're talking about. So as to, at this point, we have not seen a picture of the garage that.
I think there's one in our packet.
We had one in our packet.
There might be in your packet. Okay.
It is a gray with gray metal siding.
Yes, gray metal siding and a big, yeah.
White garage door. Okay.
That's right. I just wanted to clarify that we were talking about the same.
Yeah.
You were all talking about the same structure.
We have those pictures in our packet.
Oh, okay. So, yeah, I mean, I tried. My main issue with this building so far has been the water runoff. There doesn't seem to have been any kind of contingency to address how, the impermeable roof would affect the neighboring properties. So that was, I tried to talk to him about it and maybe extend a downspout or divert the water another way. So far, there hasn't been any change or any attempt to divert the water. That was my initial, I tried talking to him several times. I showed him the pictures, the same pictures that you have, where there's ponding clearly from that structure. But, since receiving the letter to inform me of this meeting, I wasn't quite aware at the time when I called codes that it was in excess, that the square footage was in excess. That building does kind of loom over my property. I noticed that in his permit application, there's no mention of the height, which I think might, I didn't put a tape measure on it or anything, but it does seem to be quite tall, and it kind of looms over our backyard. Yeah, I mean, that's pretty much why I'm in opposition. Of course, without, there's been no inspection. I would assume that should the building be allowed to stay, that it at least goes through the inspection process. But really, I sent a picture yesterday. I'm not sure if it made it to y'all. I know it was late, but it was the view from my backyard looking at the structure. I don't know if it made it.
I've seen several pictures of it, I think. I don't know if that picture made it, but I got a sense of the size of the building and portion of the property.
It does dwarf most of the houses in the neighborhood. I mean, my house is on that property is, I think, 700 square feet. I think most of the properties in that neighborhood are quite small. So in my opinion, it's a little bit out of place. I certainly wouldn't begrudge a neighbor for putting up a storage shed or anything like that, but it does seem out of place. And really, my main contention is the water runoff. And there's been no attempt to mitigate that thus far.
What side of the structure are there downspouts on it?
There are downspouts on it, and there are the sort of the accordion style drain extensions that are pointing, basically to that garage that's on my property.
Okay. Do you think that if there was a redirection of that, either to the rear of the property, that would be something that would alleviate that issue? I
think that would help. I don't know that it would mitigate it entirely, but I would expect at least some attempt to do something.
And there was also something, I believe there was something in the record that was presented to us indicating an issue with this structure that we can see here that appears to be an encroachment. can you explain that?
Sure.
Okay.
I bought my property in May of 2021, and it was there. My understanding is that it's been there since the 90s. On the property report card, I think things from Old Hickory Boulevard, when they got switched over to Metro, they only went back so far. And so it's listed as, I think, 1997 or 1998 that the footprint of that garage has been there. So that's my understanding, and we intend to, dispute the boundary and correct the boundary.
And that's not before us, and I
Right.
understand there's something else going on about that, but. Any other questions for the opposition? Okay, we'll close thank you, sir, we'll close
Sure.
Yeah, we'll allow the rebuttal, and thank you.
Okay, thank you. Thank you all.
Thank you for the rebuttal time. Some of what Mr. Emerald said just isn't true. Mr. Campbell texted him 2 weeks ago, said he had someone out looking to mitigate the water issue and never received a text back from him. At the time that Mr. Campbell did the survey, that's when he discovered that his neighbor had a commercial building. He calls it a garage. He's trying to use it as a nail salon, from what we understand, but that it encroaches 9 feet into his property line. So it's basically become a dispute about, the land and also the drainage issue. Again, we've gotten an estimate. It's in your packet to mitigate the drainage issue. It's about $3,500. Mr. Campbell's willing to proceed with that. In order to reconcile that situation. He's not willing to give his property away, but then that's what's been asked of him. Again, I don't know about looming. There are many garages this size in the neighborhood. I don't see it looming over anything. He doesn't live there. Again, it's going to be used for commercial purposes. And so that's basically our response to Mr. Emerald.
Do you have an idea of is the height in question as far as codes is concerned? I guess that'd be a question for Liz there. Is that part of what's the issue here? Is it just the allowable area for the garage?
I was just looking at that because I had the same question, and I don't see where it's been addressed because when I'm looking at the site plan that's been submitted, it doesn't address that. So what I'm going to do is go ahead and go into CityWorks for now and take a look and see if I can find any information about the height of the structure.
Okay.
Yeah. And I will say it sits in the very back of the property.
Right.
There are no other homes around there.
Do you have any idea of what the height of the structure is?
It's tall. I don't know the exact height, but it is tall. Yes.
How many floors is it? Is it
It's just one
is it
floor.
Single story?
Yeah, it just has a higher roof line on it because he has a boat, and so he needed the higher roof line.
I think you testified earlier that the house is a two-story house. Is that correct?
That's correct. It is a two-story house.
Is the height of the structure less than the height of the house?
I would think
Probably.
so. I know you can't see it when you pull into the driveway.
Okay.
You cannot see over the home to the structure.
Okay. Thank you.
Okay, no further questions.
Thank you so much for your time.
Close the public hearing and discuss. Well, my mic is on, so I'll speak first. I don't see a hardship here is what I see. Another thing is I just don't accept that somebody tried to call Metro and couldn't figure out how to get a permit. So those are my two thoughts on it. But aside from the fact that I just don't accept that, it seems to me a reasonable conclusion that this was just built hoping that nobody would get wise to it. But that aside, I don't see a hardship here.
I agree. That's I don't like it when people build stuff and then come in and say, "Hey, I'm sorry." I just didn't think it was a hardship. It almost seems like it's a self-imposed hardship. Like talking about the commercial activity on Old Hickory, that stuff pre-existed him buying it. So it's not like a huge condition changed after he bought the property. Like I think when he bought the property, you could observe that there's commercial activity. This is Old Hickory Boulevard, which is a busy road. And so I agree with you.
Well, the representative noted that he used to live across the street and had issues there. So,
yeah, I mean, I'm frankly, I'm also, just from, and my internet was working where I was able to pull the picture up, the photograph that the opposition submitted that, I think there is a concern about injury to neighboring property with the runoff that's visible. Now, I understand that they've submitted some evidence to potentially mitigate that, but, this is a situation where, it's unfortunate, but it's I don't see the hardship either, based upon the.
Well, then I make a motion that we deny the variance requested because a hardship was not shown.
Second. There's a motion to deny the request. There's a second. Any further discussion? All in favor, say aye. Any opposed? Okay. That is denied 5-0. All right, next case.
Case 2022-143 is a request for variance from the side setback requirements for a single-family dwelling and detached garage located at 1042A Scoville Street, zoned R6A. Before you here is a visual of the zoning map of this area as well as the aerial view of the neighborhood. A photo of the dwelling. This is a copy of the original plat, and I just put in red there the part that was blown up to give an indication of where this property is located.
Ms. Waits, I don't know if there's someone from Metro that can. Our TV screens are not working here. We got like Minecraft happening on them. So
okay.
I can see on here, but don't slow anything down. But I don't know if there's somebody that could come.
Okay, thank you for letting me know. And if it's okay, I know the applicant's going to make a presentation, and during that time, I'll make sure to call the IT assistant and ask for him to look at that. I was looking at this old plat because the old property lines look a little different than what we see today. And this is a closer view of the space in between the subject structure and then the neighboring structure. And here we have a copy of the site plan. I think I did go ahead and include copies of the detached structure since someone who'd written in had questions about the uses. So that's there in case you all would like to look at that after we hear from the individuals that are present today. So thanks. If you would please state your name and address.
Good afternoon. My name is Jay Wallace Irvin. I'm with the law firm of Lewis Thomason here in Nashville, 424 Church Street, Suite 2500, 37219. I'm here on behalf of the applicant, JDG Investments. I understand your all's computers may not be working, but this is a request for a variance from the side setback requirements for 1042 Scoville. If you can see either on your screen or on the screen behind you, you will see a site plan that shows a number of different colors, primarily blue and red. I will say that the colors, or the blue color, and Ms. Waits, I apologize, I would like to reserve 3 minutes for a rebuttal. But the blue is indicating the structures that are located on 1042 Scoville. The adjoining property is 1046 and 1048 Scoville, and is likewise two residential structures. The only difference is, or two residential units, I apologize. The only difference is instead of being detached structures, it is a single structure. For the purpose of this variance affects both properties, but is only made on behalf of the 1042 Scoville property. In speaking with staff, we understood there needed to be some sort of baseline, and as I'll get into, the more efficient way to handle that was to only proceed with a variance as on behalf of the 1042 property. So I believe Ms. Waits was handing out a couple of additional exhibits that were supplementary. And I apologize for not having this here sooner. There was an issue. I didn't realize that Mr. Hargis was still out of the office when we were trying to get those to him earlier. But the first is a copy of what you're seeing on the screen, which is a copy of the site plan. The second is a timeline of these two projects. Both projects, again, are 2 residential units on each property. These are differing owners. The 1042 project, which is what I'm here on behalf of, predates the second project. Construction on the second 1046 and 1048 project trails construction on the 1042 project by roughly 4 months throughout the process. Unlike many of the variance requests that you all received, this is for 2 issued permits, or technically 4 issued permits. There's a separate permit for each residential structure on 1042, as well as the 2 accessory structures in the rear. Both of these particular properties are subject to horizontal property regimes that are recorded with the Davidson County Register. Both of those horizontal property regimes include site plans that were surveyed by 2 different surveyors using 2 different survey points and benchmarks when they were coming up with their surveys.
And let me ask you about that.
Yes, sir.
Here's what I gleaned is your surveyor doesn't admit that he erred. Their
Correct.
Surveyor doesn't. This is just a case of the monumentation from this neighborhood in 1856 is
That's
gotten
accurate.
wacky, and then as happens in surveying, as you survey off more lots, that discrepancy becomes more visible. And so your surveyor is not, you submitted a site plan with a survey from a licensed surveyor.
Correct.
And then that surveyor isn't conceding that he got it wrong or she got it wrong. I think it was a he and Mr.
Correct.
Hoover.
It is.
But, and their surveyor is, they just can't agree about the proper monumentation. Correct.
That's accurate. In terms of these lots, and this is not a great description, but it's essentially if my hands are Scoville Street, the properties now do this as opposed to this. So when you look at both projects, both structures on each property comply strictly with the requirements of their respective permits. And you can see that from this diagram. The structures on the blue side, 1042, are, in terms of side setback, are 5 feet off for the residential structure of the surveyed property line that is included with that permit. The same holds true with the accessory structures being 3 feet off the permit line as it is in that survey. The same also holds true with the properties that are not a part of this variance but are going to be affected potentially by this variance at 1046 and 1048 because they also, in line with their survey, strictly comply with their permit in that survey.
Right. And if your surveyor is accurate, you don't even need a variance. But what
we don't. It's for the purpose
avoiding a lawsuit about having a judge
Correct.
decide whose survey is correct.
That's accurate, because all of the structures that are at issue here are on their respective properties. So the property line is not an issue for the purpose of this variance request. It's just the only question is what is as out of an abundance of caution, making sure that the structures and the completion, because neither of these projects have a certificate of substantial completion or a use and occupancy permit, because neither of them can get that until this issue is taken care of, and we can certify that either one is right, one is not. The more efficient way in speaking with staff was to say, well, we will approach it by seeking a variance on behalf of 1042, assuming for the purpose of this board to give the board a baseline of what the variance could be granted off of, to say, well, we'll base it off of the survey at 1046-48, even though we disagree with it, but to be able to say, for the purposes of obtaining a use and occupancy permit, that those set-off distances should be what they are as represented here for the purpose of being able to move forward and obtain a use and occupancy permit. That's accurate.
And I would assume that if the variance isn't granted here, that based on the cost that your client has into this, rather than tear these structures down, there's probably going to be a lawsuit, and probably both parties will spend a lot of money, I would guess, on a boundary line dispute. Would that be?
There is, but even that, the issue is there will have to be a decision from this board approving the structures as they are now, otherwise they all have to come down. And that's the problem. As it exists right now, all of the structures on the 1042 property are complete. The only reason those have not been finalized is because they can't get the use and occupancy permit until this issue with the side set-off is addressed. The same issue affects 1046 and 1048, although they are not before the board right now, simply from an efficiency standpoint. If you could proceed with one variance and take care of both properties and allow the structures to remain in their existing state, that was the more efficient means of moving forward.
I'm sorry, the applicant wanted to reserve 3 minutes for rebuttal. Does he still got time? Okay, you still have some time. I interrupted you with a question.
No, you're fine. So, and I think I was going to go through the factors. I think we've addressed all of those in talking about this, but this is certainly not a condition that has been self-imposed, as I'm sure this board sees, particularly in downtown development here recently with some of these lots. Over a period of 150, 160 years, blocks change, surveying methods change, and so they're not exact. In speaking with staff, we talked about a number of other lots within this general area where some property owners had lost up to 5 feet of their lot over a period of time. And it's one of those that, had these projects not gone on or had not been going on at the exact same time, this may not have been even anything that anybody noticed at the time. It's just, this is a condition that we find ourselves in now. It's not something that was identified until early this summer when the accessory structures for the 1046, 1048 property started being laid out, that they said, hey, we've got a question here about the boundary. Again, all of these structures are on their respective properties. It's just a matter of, for the purposes of being able to move forward and close out the permits, is seeking to modify the setback requirements as you see here. Now, one thing I will note is in the materials that have been provided so far, I don't know that we had specific distances that were identified on the original document that might be in your packet, which is why we have the second variation. But you can see the distances vary from 9.5 feet at the front on the Scoville side of the residential structures to 8.5 feet on the back side of the residential structures. That's a set off between the two structures. Each of them, again, would be 5 feet off of the property line as it was submitted and as they're surveyed. The same holds true with the rear accessory structures. Each of those are 3 feet off of their respective boundaries. The only issue is that you run into where there's about 3.5 feet of separation between those structures on the rear, as opposed to being 3 feet off of the property line. So in terms of a variance, again, to provide the board a baseline, we would be requesting that for the minimum setback distance be modified to 3.1 feet on the residential structures as a side set off, and I believe it's 0.41 feet on the rear.
And so let me ask you if this math is correct that I did. I'm not saying it is, because I think you've got a situation where two surveyors disagree. But
correct.
If you assume their survey was correct for purposes, then you would need a 5-foot setback, side setback for the residences. What you have is 3.5. I went through the materials, and this is the math I did. That just assuming that their property line is correct, you should be 5 feet from it. You're 3.5 feet from it, and then
I think it's actually 3.1 at the rear. Okay,
3.1 at the rear. Okay, and then if their survey were correct, again, I'm not saying it is,
sure,
that the required accessory setback would be 6 feet, and you're at 3 feet 6 inches.
Well, no, they're the rear set.
What the accessory is
the accessory setback per the permit is 3 feet. Okay. Where if you assume that that the 1046, 1048 survey is correct, right, the front of that would be 0.82 feet off of that survey line. 0.82. 0.82, okay, and the rear of it would be 0.41.
Okay, so you'd be going on the accessory setback from 3 feet to 0.82.
Correct.
Okay, all right. That's all right. Thank you.
Thank you all very much. Appreciate it. And I'll reserve the rest time for a rebuttal.
Okay, opposition.
Do I hand these up to y'all?
Thank you.
Okay.
My name is Blake Fuson. My address is 1044 Scoville Street. I share a property line with the appellant, would be directly affected by this variance. I'm in the final stages of completing my new home, which we constructed per zoning regulations. My home is 5 foot off the property line, and the detached garages are 3 foot off the property line per the zoning rules. The appellant built his house 3.5 feet off the property line, and he built his garages right on the property line, as you can see in photos 7, 8, 9, and 10.
And then, Mr. Fuzon, when you're saying he's built it right on the property line, you're going off of your survey, correct?
We've had 3 surveys done, and it's actually 1044 and 1046, not 1046 and 1048, Scoville, like he said. It's 1044 and 1046.
I think I saw one survey in the.
No, we've had 3.
No, it's one survey.
Can you state?
My name is Bill Fuson. I'm Blake's dad.
Okay.
I have a financial interest in this.
Can you state your address too, Mr. Fuson?
I live in Murfreesboro.
Okay. Can you give us your street address?
Yeah, 108 Tennerton Lane, Murfreesboro.
Okay.
But
So you're saying you've had 3 surveys?
Clint Elliott is the surveyor, and he's been out there 3 times.
Okay. The same surveyor has done 3 different surveys.
Right.
Okay. So here's the question for you though. What is it? What I see here is what I've seen a good bit of is you got 2 surveyors who have decided to just have a disagreement about the monumentation that ought to be used from an 1856 platted subdivision. Why is it that the surveyor on the other side is wrong?
Well, can I start there? Well, the same builders have actually built 2 other properties across the alley from us on the same block, literally catty corner. They had no variance there. They used the same surveys they used on ours, and those were just fine. They're literally right across the alley from us. Same block. Used same surveys, same setbacks, everything as everybody else. They had no issues with those. Now they want to claim they got an issue with this, want a variance. I can see no reason to grant this variance since the appellant's lot is the largest lot on the whole block. They have 60 feet. 60 feet. We have 50 feet. A lot of the other ones have 40, 50. They have the biggest one on the whole block. And I've been told that the reason for a variance can't be solely financial. And that's the only reason that I can see the appellant will be granted a variance. They built their house and their garage in the wrong spot, and now he's asking for the rules to be changed so he won't be held accountable for them. Once again, I strongly oppose this request to disregard the standard setback as defined in the Muni Code R6 for a lot.
And to clarify, you're referencing the blue lot, correct?
We turned in some pages. I can't really tell what they have, but if you want to look at page 4, we'll show you page 4 on the folder that I gave you guys.
It looks like we're the red up there.
Yeah. See, what happened was
Blew it up so you could see these numbers.
So which one are they referring to?
They are the red, I do believe.
what happened was I did one structure. I wanted to do 2 separate structures just like they did. I wanted to do 2 separate structures, 2 detached garages just like they did. But we didn't have enough room. My contractor said, can't do that with the side setbacks. You can't do that. Well, they did it. They went ahead and detached their garage, detached their houses, detached their garages, which I can only assume is for financial gain. Their houses are 6 feet apart. Their garages are 6 feet apart. But that pushes them onto my property line. Their garages are on the property line. Might be, I think we got it in there, 4 or 5 inches off the property line on the garage. Their footers actually come subterranean onto the property line, where it makes it impossible to even put a fence down. You can't do anything because you're hitting their footers. And their houses are 6 feet apart. I mean, it just looks like they should have done a combined unit to me, like I did, instead of dividing them, and they wouldn't be encroaching on my property line. They also bought 10 feet from the neighbor on the other side back in 2004, which gave them the biggest lot on the block. Why would they not go over to the right into the 10 feet they own from the neighbor instead of going over my way? They got 10 extra feet. They bought that. They have the largest lot on the block. Why do they need to come my way? And you can see in the pictures how far off on page 7, 8, and 9, and 10. Let's see, 7 or 8. That shows a good representation of the how far off they are off the property line in their garages. 6 inches off the back. runs to the alley. And the front part, at the very most, is 1 foot 2 inches. At the most. I'm trying to give them the benefit of the doubt on that. There. See, page 9 shows, I'm on the left, on the top left picture. That's my garage that has the ladder leaning up against it, and that is their garage on the right. We could barely even get anybody in there to work. You can see how close it is. It's literally, you could barely even get a ladder in there. And their garages, they have permits to build, just to frame out their garages. Well, they have electricity ran in there and everything else to make a livable dwelling upstairs. My concern is if they do that and granted this variance and they have a fire up there, which they're going to have kitchens and everything else up there. If there's a fire up there, that is directly going to jump over to my house. It's not 1 foot off of where the rooftop is to where their second story is, where they built the kitchen and their living space and all that.
And one thing I want you to note in one of the handouts, there's a copy of the building permit for one of the garages.
This is in your handout?
Yes, sir.
Okay.
It says that the knee wall cannot be more than 16 feet. Well, if you go over there and measure it, it's 19 and a half feet.
And I read that. That's not before us right now. I mean, that's not. We don't have any information that they're violating their permit in any way. So,
well, it's just part of it, and it's kind of the narrative of using the old standards. I've never heard of Lotcrete, but I can understand maybe a little bit of variation down through there. But why would it only be the issue with our one lot? They developed several other lots right adjacent to it, had no problems.
Same survey.
It just, and I assume they used the same survey. So it just doesn't seem like. I mean, they had 1,500 extra square feet on their lot to use. It's the largest lot on the whole block. Why did they have to move over to our side? And if you take I think the front focal point of the surveyors at the Scoville Street and go back, even their main structure is over by about 1.5 feet past the side setback. And it gets back, and if you go back, one of the pictures I there shows a little tape about 5 inches off. That's even before brick is applied to the garage. Once that brick is on there, it's going to be sitting right on the Scoville, on the property line.
So, I don't know if there's what it is. Like, I think there's two different setback variances we're reviewing here. There's one for the main house and the one for the garage. Do you have less of an issue with the one on the main house and more of an issue with the one on the garage?
Yes.
Yes. Okay. Yeah, I know you have an issue with both. I understand that, but but you have more of an issue with the one on the garage.
It just seems like a total disregard. Like they're asking for forgiveness instead of permission.
May I speak? And I get y'all see it that way. I mean, I understand, and it's very close to you, but what I also see is they've got a licensed surveyor who they relied on. Y'all have a licensed surveyor who y'all relied on, and the surveyors, just as they sometimes do, and especially in old neighborhoods, they just disagree about where the property lines are.
But they didn't disagree with when they built their other one right across the alley. They used the same surveys. They used the exact same survey and the same lines.
Do you have that survey to show us where? Are you saying they
had no variance, so they used the same surveys as on the whole block? We've got probably 15 new structures on that street and on that block. This is the only variance they've had to call for. Everyone used the same surveys, same lot plots and everything else, and this is the only one they have a problem with. It's because they detached their houses. It's nothing but financial gain.
It just appears it's all for financial gain. By detaching their properties, they increase the value of each one 10 to 20% maybe. So we wish we could have done the same thing.
Absolutely.
So can I, and I know you want to speak, I just have one question. So the other ones that are built, are they one, like?
They're one unit. Yep.
They're all attached.
They did not detach them. Yep.
Okay, thank you.
This is the only one they detached, and this is the only one they're having to call a variance on because they're encroaching on the property line.
Okay.
May I say something? My name's Patty Fuse, and I live at 910 Peconic Place in Murfreesboro. On page 9, there's a picture of the back of the property, and it shows my son's foot pointing to the actual pin. On the the third
Did you say
time,
page 9, ma'am,
Yes, sir.
of this package you gave us?
it should be, yeah,
Okay,
it should
all
be
right.
page 9, I'm sorry. But it shows the actual pin, and then you can see their building to the left of that, and our building is to the right. It shows, and then you can also see the property line stake shows. Now, that is our surveyor did that. However, that is the actual pin. And our surveyor also spoke with their surveyor about it and showed them. So that is the actual pin. Our surveyor went down the street, both directions, and came back in order to measure to make sure he was correct. And when he did that, this was the pin that he came up with. So them using an old survey, which if you ask me, there's no way they would not have used an old plat, because in 2004 they added 10 feet. So they would never have used that. That would have said they had 50 feet, not 60 feet, and they wouldn't have built over there. So saying that they had used some old neighborhood plat could not be correct.
Was this pin in place prior to the construction beginning on the 1042 property?
We actually could not build for 2 months while we went back and forth with them, because our builder wouldn't put our structure up because the electricity came in the back and he wouldn't put our structure up. So for 2 months we went back and forth with them. Their building had already been built, but we didn't want to build unless we were correct and we were in the exact right spot that we needed to be in. So our house is set for 2 months with no electricity.
So I just want to make sure we're clear. You're saying that the structures on the neighboring property had been built, then your surveyor came in and put these pins in?
No, this pin was an old pin. They found this old pin. We actually have surveyed this property before. This pin has been there, and they know this is the pin. Our surveyor, I've got the surveys from where, not the surveys, but I have where we paid him to come in and do the survey. Then he came back and restaked it. Then he came back again and tried to show them that this is incorrect. When this all started, when they were building, Blake checked on it daily, and he went over and told them, hey, this is wrong. You guys are too close on our property. And they kept building, and they kept building, and they kept building. Our builders have talked to him. Our surveyor met their surveyor over there and talked to him about it, yet they continued to build their buildings. So what I'm saying is, there's no way they used some old plat, because they added 10 feet. The old plat would say 50 feet, but the old one would say 50, and they have 60 feet. So I just don't buy, I'm sorry, but I just don't buy the fact that they used some old plat.
When did you first have a disagreement about where the lot lines were? When was that first identified? Was that before the structures were built, or during the construction?
It was before our structures were built.
Okay.
We wanted to make sure we were 100% right, because my contractor told me, he said, I think they're too far over on us. I'm not going to build anything until we make 100% sure. So we had our surveyor come out. He came out again, and then they called another third-party surveyor who's supposed to be like, his word was the final word. But, and he said that we were right too. And then now we're here for them asking for a variance as a final straw, I guess.
They were actually told by our builder when they started digging the footers for the garages.
Okay, thank you.
And you stated earlier this is your personal residence?
I'm going to live in one, and I'm going to Airbnb the other one out. It's 1042. I mean, it's 1044 and 1046, not 1046, 1048. It's 1044, 1046. I'm going to live in 1044, which is the one right next to their build, to the appellant's build, and then 1046 is on the left side of it. So we're in complete regulations with all the codes and setbacks, and they're just not. They're way too close.
And they'll even be closer when they start bricking that up. So where he said they were completely finished, that they aren't. They stopped and boarded the place up, and they haven't even put their brick on it, which right now, at the very back of that garage, they're like a few inches away from our property, which they will be on our property when they start putting that brick on there. And it's just very difficult when you have the footers and you're trying...
Can't put a fence down.
Can't really put a fence going up there. And in that neighborhood, you really need a fence all the way around your property.
And that's it. If we can reserve some time to.
You will.
Oh, we can't
do that.
Okay.
Yet.
Okay.
It's only the applicant.
Oh, I got you. Okay. I'm sorry. I didn't.
We've got some time left, and there may be some more questions from.
Yes, sir.
And I do have this, well, we've actually had it surveyed 6 times, but I do have the names of the people that surveyed it, but it's over there that I could give you if you'd like it. And how much they charged us each time they came out.
You've paid for a lot of surveys.
Like
paid for all of them.
$575, yeah. And it actually says restaked, and then the next one says restaked garage. So we just continued. Our electricity came in the back, and so he did not want to build until we knew exactly where the lines needed to come.
Which I think what she's trying to say is we couldn't even do anything inside the house that required electricity, so it set us back 2 months from our completion date. So we couldn't even build or do anything because we didn't have electricity in the house. So it set us all the way back on that. That's kind of where we are at.
Any further questions from the? Okay.
We appreciate y'all's time, and thank you for taking me serious. Thank you, sir.
Thank you.
Good afternoon. I've got just a couple of points that I want to respond to. One, you heard a number of comments about a combination of a lot. JDG Investments purchased their lot in 2015. Anything with the combination of the lot was done years before they got it. What you see with the site plan, all of the site plans that were submitted, all the site plans that were part of the surveys were based off of prior plats as is required for any surveyor who's doing work. They all go to the Register of Deeds office. They pull all of the prior surveys, all of the prior plats, and that goes into making a survey. The survey that was done as part of the HOA the horizontal property regime that was recorded with the Davidson County Register of Deeds office was based with the actual lot you see on the site plan. That's all of lot 36 and part of lot 37, which is what they were talking about. It's not as though material or part of a property was added after the fact. That has been the property since 2004. That was the property that was submitted as part of the permitting process, and that is why, because it was a larger lot, they were able to put 2 separate dwelling units on it.
And so, and what I think I hear them saying is that, reading between the lines, is that they think your surveyor may have conveniently not used monumentation that the surveyor used to survey lots that were in the subdivision, but then switched and used different monumentation. But because I get what's going on here but now I don't have any of the prior surveys that your surveyor did, so that's not in the record.
Well, and I'm not aware of those surveys until we're sitting here. I know nothing about any other prior projects. I know JD&G Investments is the owner of this particular project. I haven't had any interaction with a contractor or whoever they used to build them. I have had some conversations with the surveyor that I know did this one. I have no knowledge of whether or not he did any other surveys. If there are other surveys for other projects and other plats and other site plans, those are certainly specific to those particular parcels of property, and they wouldn't have any relation to this anyway. The issue between the 2 surveys here is because they use 2 different benchmarks. In terms of, there was a question about a pin, and that the board asked some questions about that. The pin that they were referring to was not actually placed. It was part of the follow-up, that my understanding at least, it was part of the follow-up survey that their surveyor did, which marked his survey. It's not interrelated to the survey that was part of the site plan or any of the construction as part of 1042 Scoville. It's an after the fact, after the structures were built, that he put in a pin almost to mark it for the purpose of constructing the remainder of theirs.
So I have a question.
Sure.
If your variance assumes that their survey was correct, right? Because that's why you're here
for the purpose of this.
For the purpose of this.
Correct.
So is the current structure right now, is that what's 0.41 feet off of what their survey says, which is approximately 5 inches?
Correct.
So you don't have any cladding materials on the building right now, is that correct?
I would have to defer to one of my colleagues, Michael Johnson, with Kay Griffin.
Okay.
No. Not at this time.
Okay, so that would assume then, do you know what cladding materials will be going on this portion of the building?
It was brick, but again.
Doesn't have to be wood.
Okay, so possibly
As
brick, at
permitted,
least
it's brick.
some kind of cladding's going to go on there that's going to eat into that, even, it would eat into that 5 inches to some degree.
Certainly.
So it ended up being closer than the 0.41 feet if we assume their survey to be correct.
Correct.
Is that correct? Okay.
That's accurate. Regardless of the cladding material used, I will note that it will all still be on the 1042 property. You're right. The variance distance may need to change.
Right, because I was thinking if you have brick, that's going to be 2 inch airspace, 4 inch brick. You're going to be 6 inches. You're going to be over the property line.
You're right.
And then would you concur that if their survey is correct, which is what this variance is contingent upon, that the footer for the garage would be underneath the property, the adjacent property?
Not. Again, I don't know that this is in any of the materials you have. I have made a personal site visit there, and my opinion is that even the footer is on their property, on the 1042 property. It would not, short answer is there would be no encroachment with any of these structures or their footings.
Okay.
Assuming that you're talking about basing everything off of the 1044 and 1046 survey. That is accurate.
Okay. But it would be fair to assume, though, that you're very close to the property line at that point.
Oh, it's very close. I mean, there's no
even if it doesn't quite encroach, you're right on.
It's close.
It's really, you're talking about, less than 0.4%.
No, I mean,
4 feet.
That's accurate. I mean, what you will see in both the materials that the applicant submitted and from the opposing homeowner is the distances don't vary materially. The photos are what they are. Where we have a disagreement is because where the applicant is approaching the request for a variance for the benefit of both, saying we'll assume that the 1044, 1046 survey is accurate for the purpose of this variance. When you are looking at them both separately, they both strictly comply with their own permits based on their own site plans and their own surveys. It's only when you're looking at them together where there is an overlap between the surveys, which it can be one for the purposes of this application. 1042 is saying we will accept the 1044, 1046 survey for the purpose of obtaining a variance, but in terms of you could just as easily approached it from the opposite standpoint and said, 1044, 1046 should have been required to get a variance. And to be quite blunt, neither of these projects can get a certificate of occupancy until one of them gets a variance.
So let me ask you this question. So assuming that you're not granted a variance today, and obviously the neighbors don't have a variance, you're obviously going to stand on the position that our survey is correct. We don't need a variance, right? We tried to get one to obviate a dispute. Well, where do you all go from there? I mean,
you get into a very no man
on your survey. They're allowed to stand on their survey.
Correct. And as I started the presentation with, there has to be some sort of variance granted by this board if the structures on each property are going to stay in their current position and state. There's no way around that. It's one. They either are where they are and they remain in a state of limbo because neither one would be able to get a use and occupancy permit. You wouldn't be able to live in them. Like Mr. Fuson, the primary members of JDG Investments are also planning on using one of these structures as their primary residence. And so you get into a situation where nobody's going to be living in these houses. You could have litigation over a property line, but at the end of the day, even, realistically, the property line's probably somewhere in the middle, which means they're both still technically out of compliance with their permit requirements. And so one or both are still going to have to come back before this board. The only difference is when you're asking for a variance, what's that set off going to be?
Mr. Irvin, I just want to make sure I'm clear in my understanding of this, that effectively if there were a litigation that and a finding that the property line is the property line as your client's survey indicates that it is, your client would not require a variance, but Mr. Fuson's property would require a variance. Is that correct?
That's accurate.
I mean, I don't see how if Metro's not going to issue permits and one party doesn't get a variance, I don't see how this doesn't end up before a judge trying to resolve the property line.
If there's no, that's to your point. If a variance is not granted now, I think the next step was you would probably see a property line dispute, at which point a judge would come up with whatever the property line is. That's taking currently in Davidson County years. While both of these, all four units sit idle, you then, even once the property line is set, that's not the end of the process, because then one or both would still be back before this board seeking a variance, because unless it is 100% in line with the property survey as surveyed by 1044, 1046, one or both of these properties is going to be out of compliance with the permit requirements.
Is your dwelling unit in the garage, are those on separate permits? I think you stated that earlier.
On 1042, all four structures are on separate permits.
Okay, thank you.
And so as part of the application process, we listed all four permits, but it's really the two on the 1044, 1046 property side that are at issue. There is no, the other set-offs are in line with the permit requirements.
Any further questions? Thank you, sir.
Thank you all very much.
Close the public hearing and discuss.
I don't know that we can do anything about this until we know what the boundary line is, because I don't see in the code how we can grant some sort of conditional variance that's
advisory opinion.
Yeah, it's effectively an advisory opinion that if there's a dispute over where this boundary line is, we're effectively granting a variance that may not necessarily be the case.
I thought about that, and I thought, what is our role here? I do think that, if this problem doesn't get solved here, I see it spooling into litigation and a lot more expense for both parties and a lot more loss of resources. I think that we have the authority, if there is a unique or exceptional circumstance, to grant a variance. And to me, a possible unique and special circumstance is you've got a neighborhood that was laid out in 1865 when they were still using chains and they didn't have pins for monumentation. And now you've got, more than 100 years later, surveyors disagreeing on what the boundaries of the different lots are. So, that's a possibility, I would say, but it's, I personally, I do think that it's this, the boundary line is unresolved because you have two surveyors disputing it. But I got to tell you, I think both parties are going to lose if this goes into litigation. I just think that doesn't mean that, if your point is that there's not a role for us and we don't have the authority, then that's where we are. But I do think that exceptional, unique circumstance may have an application here.
Go ahead first.
Okay. My thought on it, and Mr. Pepper, you know a lot about the history of surveying, so but my thought about it is there an opportunity to treat the dwelling unit and the garage separately? As we discussed, this variance goes on the presumption that the opposition survey is correct, and that would mean that the dwelling unit would be 3.1 feet from the property line, and the garage unit would be right on the property line, and once you have cladding and whatnot. So, I do see that. Again, this is presuming that survey is correct. That does it can provide injury to the neighbor's property, and at that point, their eaves on the structure are hanging over the neighbor's property, and that's injurious to the neighbor's property, in my opinion. However, the dwelling unit, their footers are on their property, their eaves are on their property. It's closer than the setback says, but it is a pretty unique circumstance. But the garage, possibly the footers, we know definitely the eaves would be hanging over property line. They, as the opposition mentioned, they can't build a fence or, do things like that. I see an injury there, but as far as the duplex unit, I don't. So, I would be more apt to grant a variance of the 3 feet for the dwelling unit and not grant the variance for the garage portion of it. And I don't know if we can split the baby like that. I guess Ms. Waits can.
Yes, I think it was a good question, just confirming they're two different permits, so it makes sense.
Mr. Newton said partially what I was going to say. I'm always uncomfortable granting a variance when we have so much testimony and sort of visible proof of the real injury to a neighboring property. I think it seemed to me that we had testimony that maybe the opposition gave notice that maybe there was a problem, and which was within their right that they continued to build. But if you had notice that, hey, this might be an issue, I feel like you could have solved yourself a lot of expense. Like, I don't want to concern myself in the expense because I think maybe some of that was self-inflicted wounds. So I think Logan's idea of trying to split it, I'm definitely listening and open to that. But, looking at these pictures, imagining what it'll, because you said, that it's not even finished, imagining how close that is, that just, not just these property owners, but the future of these properties, that just seems I don't know, that makes me uncomfortable. But I think it's a hard issue, and I think you're right, Mr. Terry, everything that you outlined, I completely agreed with, but I am a little concerned about the injury to the neighboring property. So,
it is very close. I see what's going on here. It's very, very close. I get it. I think it's really an unfortunate situation. And I think it would have been nice if the surveyors came out with the same surveys, and we wouldn't have this issue. But and I don't see it as being the fault of. I don't see it. What I don't see here is. I really don't see any fault. I see that two people got site plans and surveys, and they're entitled to allow them. And I really don't see a financial motive here. Everybody wants to do is. Everybody now in Nashville is pushing the setback lines because you want to get as much square footage as possible.
I'm probably more inclined to not act in this instance because this is an advisory situation on our part. No matter who wins or who loses today, whether we grant a variance or we don't, there's still, in watching both sides, there's not a whole lot of wiggle room for either one of them. All right, now that wasn't planned, so pun was not intended. So it's going to end up in a courthouse at some point in time, one way or the other. And it's, I don't like giving advisories personally.
One of my thoughts on this, one of the considerations I had is whether we move to defer this and ask the applicants to have the surveyors present, whether that would accomplish anything. The other piece is whether we could defer this with the idea in mind of allowing the parties to discuss a potential resolution of it, because it appears, we've heard testimony today that I think, frankly, we will probably hear again in a parallel variance request if the determination by if a court effectively rules that the applicant's boundary line as determined by the survey is correct, then the opposition today will need to seek a variance for its structure. And so what I'm concerned about taking an action that we're going to wind up back here having to do the opposite, and it's all dependent upon the outcome of a particular case. And so, this is the difficult thing is I have a hard time saying yes or no today because I am frankly hung up on the fact that this appears to be a boundary line issue that is outside of our jurisdiction. Effectively, they're saying if we win, give us the variance so that we have it ready to go in case we win.
Well, I actually think what they're saying is if they were to lose, yeah.
Right, correct, yeah.
I mean, I'm with you that it does seem, if we're going to stretch to give a variance, I think it has to be under the exceptional and special and unique circumstances. And it may well be a stretch. And I mean, probably my...
You're mediated?
Well, I mean, I have represented people in boundary disputes. I know how expensive they get. I know how time-consuming they get. I just think that's, it's a really unfortunate situation. I don't think the surveyors, it seems to me like there was testimony that they had a discussion, and I just think they just disagree, and they do sometimes about what's the correct monumentation. So I don't, it's a...
Yeah, I mean, to me, it sounds like that. Effectively, I mean, I've litigated boundary line disputes as well, and to me, the way this should work is somebody needs to go to Chancery Court and get an order that says, the boundary line is X, whether that's an agreed order, whether that's something that's issued by one of our chancellors here, and then we can decide, whether a variance is appropriate or not based upon that. And I know it's not easy one way or another, but I mean, frankly, I think that this one very well could wind up in litigation anyways. And so it's kind of, somebody's probably going to head to court no matter what. It sounds like it to me. Frankly, I think we can defer the case for a period of time in order to give the parties an opportunity to potentially discuss it and or for someone to file a petition and try to get some, an expedited declaratory judgment that says one thing or the other.
I like I kind of open to the idea of deferring it because maybe today's discussion will kind of crystallize the parties about where this goes from here, because I do think that if it doesn't get worked out, then it would go to court, and then somebody's going to be potentially a big loser, and then they're going to be back here, and everybody's going to spend a lot of money. So maybe
It's hard to make a setback determination when the water is about what the actual boundary is.
Right. Yeah. I mean, that's right. I mean, we have to assume, as Mr. Nick said, we have to assume that the applicant survey is not correct, and that they're asking for a variance, and So
we've got a survey we built wrong on, but we want you to go ahead and do something to fix it. And I just don't like that posture. I'd rather have them. I like the idea of kicking it down and letting them get together and see if there's some room, although I didn't see a whole lot of movement out there. And we don't know whether they have or they haven't either.
Well,
and the other side of it.
And if we are going to do this, I would like to reopen the public hearing briefly so that we can hear from the applicant. And frankly, we can ask the question of
any objection
of the opposition on the amount of time that would make most sense.
No objection to that. Okay, so we'll reopen.
Mr. Irvin, if you've heard our discussion, if the decision of the board today is to defer this in order to give the parties an opportunity to speak and or somebody to seek a declaratory order as to what this boundary line is, what time frame feasibly do you think would work for your client for a deferral?
before I answer, in terms of the board's meetings, what do you happen to know what the board's next meeting is is there a meeting in the middle of December before the holidays?
Yes. I think so. We have a December meeting.
December 15th.
15th is a Thursday. Sorry,
And that would be the second meeting in December.
realistically, it would probably be the second meeting in January. And I say that strictly because of my schedule. I won't be in town on the 15th. Personally, and I think Mr. Pepper would agree, mediation, I'm a huge proponent of. I don't think it's something that you would see here. Negotiation, further discussion, it's always something that in my opinion, would benefit parties, regardless of dispute. I think JDG Investments would probably be open to a discussion of that, if that's the way that this board wanted to go. But I would note two things. One is this is 4 separate permits that we are looking at. And so if the board was looking at something like Mr. Newton was talking about, where the residential structures, nobody seems to have a problem with moving forward with a variance on the residential structures as well as the accessory structure that you see in the top right that does not appear to have any relationship or any opposition to having a variance be granted for those 3. If there was a deferral, having it solely relate to the accessory structure closest to the property line. But the other thing I would note is that in terms of this board's concern with rendering advisory opinions, I just want to remind the board that this board doesn't have, no decision of this board is going to have any effect over what the property line is or isn't. These are lots that are numbered pursuant to the plat that's been recorded, and they are always transferred according to the plat number. There are not meets and bounds descriptions on this, nor would this board render a decision that affected the property boundary or provide a meets and bounds description. The only portion of this request that is at issue here, it appears that's still an issue before the board, is what the set-off distance would be and whether a variance could be granted for that for the one accessory structure at the rear of the property. Again, although that per the permit, there's not a code requirement for set-off.
I think we opened it up to ask you about continuing it, so it's not fair to the opposition.
I can appreciate that. If you want to give them an opportunity to respond, I'd be fine with that as well.
So,
I just wanted to clarify that the property line itself is not before the board, only the set-off, and that's not a code requirement, it's only a permit requirement. So any decision on what the set-off would be would not affect the property at all. It's only affecting whether or not any of these structures can be utilized as they're intended to be able to get a use and occupancy permit.
Okay.
And again, I have no objection if the respondent wants to.
So Mr. Fusen or Miss Fusen, there are 2 Mr. Fusen, so whichever, one or both of you be fine. So do you understand what we're discussing up here?
Yes, sir. And talking about what he had said.
Opportunity to discuss. And I think some of the board's concern is going to be that, I think you've heard it up here, that if it doesn't get resolved here, they're not going to go tear the building down and say, we agree with y'all's property line. The next thing y'all might get is served with a summons from Davidson County Chancery, and then you're going to be calling a lawyer, and they all want money.
Well, they're using a lawyer.
Can tell you that. So.
They retained a lawyer. We didn't.
But I guess what we're talking about is giving y'all a chance to think through where this goes from here, because they're here today saying we're willing to accept that for purposes of trying to get a variance that y'all's property, y'all's surveyor is correct, but they're just doing that for a very limited purpose. So anyway, how do y'all feel about a deferral so y'all can try to discuss this and reach some kind of resolution?
Okay, this is not a court, but does it matter if we were to bring our surveyor in? Because I think there was an agreement between the 2 surveyors that the property line might vary 2 or 3 inches. It wasn't very much. So I just wondered if that was something pertinent to
What I
this.
see in the materials are signed and certified surveyors by that they're different. I just can't imagine that one of them's going to come in here and back up on signed off.
That's why they're in there asking for a variance, because they've already found that our property line was right. And going back to what he said about just trying to get a variance for that one garage, well, if the one garage has to move, then it's going to be too close to the other garage. So I don't see how you could just grant it for that one garage, maybe for the houses, but not for that one garage, because if that one has to be moved over, then it's going to be way too close to the other one.
Okay, and we hear you on that. So how do you feel about what we're discussing up here, which looks like it's the best, we think maybe the best solution we can come up with today is to defer it, to give y'all a chance to try to discuss this and work it out. And I think we're talking about deferring it to January.
Who would we be talking to?
The appellant?
It would be, the idea would be deferring this so that the boundary line is here. And so, and part of our concern is that that's a legal issue that needs to be addressed before the board can, issue an order allowing a variance from the application of the zoning code. Because if a court, for instance, were to determine the boundary line aligned with what the applicant's survey said, well, that would require, as I understand it, a variance from you all. And so I think the issue is we potentially have two competing requests for variances that there needs to be a determination or some sort of agreement as to where this boundary line is. And then at that point, we can address the issue.
Who would we be talking to about an agreement with the appellant?
Yeah, I mean, I think in light of what's happened today, I would think about, you might want to be thinking about where does this go if it didn't resolve here?
I'm just worried about resale value as well.
Who would make the final determination on the exact property line?
Chancellor. Yeah, I mean, I think if it's not resolved here, then because we're not judges and we can't resolve the boundary line dispute. So I think it would.
So we go to Chancery Court.
Go to Chancery Court in Davidson County. Yeah.
Can I just say one quick thing? We didn't just have one surveyor come out. We had Jonathan Plotzer, Jacob Gregory, and Nathaniel Smith. 3 different ones staked that.
And Clint Elliott.
And Clint Elliott.
And
so we did. Yeah, we did have multiple people come in.
We understand. We understand and appreciate that. We're sort of we're at the point now where that's
gotcha.
That's fine.
All right, so we'll close the public hearing. Thank you.
Thank you.
Okay. You have a vote.
I will move that we defer this to the second meeting in January.
Okay. There's a motion and a second to defer it to January 2nd. All in favor, say aye.
Second meeting in January.
Second meeting in January.
Second meeting in January. All in favor, all opposed. Okay, that passes.
Explain to them what we just did.
I think they understand. Yes. Yeah. All right. Does anybody need to take a break before we can? Okay. So we're going to take a 5-minute break, and then if we can go back to case 110 that we deferred, if our applicant's here for 110.
Okay, we'll call the meeting back to order. The next case on our agenda is case 2022-110. This is a request for a variance from the side setback requirements to construct a rear carport at 1601 Shackleford Road in the R10 zoning district. Before you hear, we've actually already looked at these slides. Actually, some of the board members may not have. I'll do the full presentation again. This is the zoning map for this area and the aerial photos. So you can see how this property fronts toward Shackleford, and then the property to the rear of it fronts toward Belmont. This is the front of the subject property, and then to the top left, you'll see an aerial photo that was blown up a little better to be able to get a sense of the subject property, and then the neighboring parcel that fronts toward Belmont. Down below is a photo of the structure, or what's remaining of the structure. It's been partially deconstructed, and then the home to the right would be the neighbor's home that fronts toward Belmont. Some more photos of the proposed structure, the purpose of which appears to be would have been, prior to deconstruction, but the purpose of the application is to have a covered carport for the vehicle of some sort that's there under the tarp. And then we have the applicant's, it's a survey where this applicant has shown the site plan, or where the structure that was constructed was placed on the property. The portion of the structure that's in white, if you kind of look at the little part that I zoomed in on to the right, so the block that's in white on the left is going to be a portion of the proposed structure that's in the right-of-way, and then the part that's in the black hatch is going to be the portion of the proposed structure that would be inside of the setbacks that would not otherwise be allowed without a variance. So with that, I would ask the applicants to state their name and address before beginning their presentation. You have 10 minutes, and there is opposition to this, so you'll have 10 minutes to make your presentation.
I'm Gil Easdale, a homeowner at 1601 Shackleford Road, and this is my wife, April. Please accept my apology for being late. I've been to 2 BCA meetings, one just a month ago, and it was at the School of Education, and I apologize to everyone who had to wait. Thank you for hearing our request. I'm sorry to say that our mediation attempt failed. The 20-foot setback is a rule that is applied as a blanket across all situations in our neighborhood. Ours is an exceptional situation and is the reason we are here before you. If I may, are there any other photographs?
We've got some we can pull up.
I was going to describe the overhead photograph of our property that I submitted. The blue dashed line represents the 20-foot setback, and the red.
Let's see if we can get that picture up. Do you want us? Okay. Do you know the picture he's talking about? Is it one you've seen? Is it one you submitted in the package, Mr.
I submitted it to Tamika Jenkins about a month, maybe a little over a month ago.
I don't have any photos in the slides besides that one. I could try to find it, and I'm sure it's in the board's packet, the one that he's referring to.
Okay.
Okay, go ahead and proceed. We'll try to find it in our packet.
It was simply to just show the 20-foot setback, and then also a one that showed the proposed position for our carport. You can also see from that, or even from the overhead of this that you guys had, that the board has already granted an exception to the side setback for us to build a bedroom extension. Our home's on a corner lot. It faces Shackleford Road and sides against the dead-end portion of Belmont Boulevard. I think I need to include this piece of information. Apparently, I made a mistake when I did not obtain a permit to build our original carport. Only 3 years earlier, we had been given permission from this board to use all of the setback in building our home addition. I spent over an hour and a half searching online through the code's website. I found code regarding carports, but never any mention of a permit being needed. I also found code addressing many other types of structures where it was obvious that permits were required. My assumption was that as a carport, it's a fairly temporary type of structure, and that explained the absence of a permit requirement. I have since been invited to the environmental court, being cited with failure to obtain a permit, not for carport, but for an other structure. I even discussed this with the installer, the question of a permit. They said that they have installed many of these in Nashville area, and hardly ever has anyone required a permit. Finally, having assumed that the carport is a temporary structure and could be moved easily if needed, we have in fact done just that, as we have removed the original carport that we built last year. Now we wish to build a 10 by 14 foot carport in the 20-foot setback of our backyard. In 2018, this board unanimously granted us an exception to build a bedroom addition in the same setback. The carport would be in the same area as the setback, would be 25 feet from the side street of Belmont and 5 feet from the rear property line, only 3 of which is required by code. The board's decision was based upon the hardship that I described. The first and primary is an extremely large and no longer appropriate 70-foot right-of-way applied to only this single dead-end section of Belmont Boulevard. The present right-of-way was established in the 1930s when a large 2 to 3 acre lots with back alleys were planned along the course of the proposed Belmont Boulevard. Belmont Boulevard was to continue on to Harding Place as a wide primary thoroughfare. Of course, that did not happen, as now the street dead ends after serving 11 homes, obstructed and terminating at a townhome complex, and then John Trotwood Moore School. Additional hardship relates to topography of our lot. I submitted pictures that did demonstrate the topography issue. We presently park the camper on a berm created when addressing flooding problems in our backyard. This berm is 3 feet higher than the rest of our backyard and is at Belmont Boulevard grade. It's been suggested that I could build a parking pad that could be created in the center of our backyard to avoid setbacks. Additional fill material, retaining wall, reconstruction of our backyard would be a significant burden. We have very little usable building space in our backyard, and front yard for that matter, due to the large setbacks applied to our corner lot. Another hardship relates to the overhanging walnut and hackberry trees. We presently must cover our small van with a tarp, which in my opinion is not very attractive for us or the neighborhood, but it's the best we can do to protect our van from the sap and debris of these trees. The tarp unfortunately collects water, which is a breeding ground for mosquitoes in the summer, and presents danger for me when I must climb atop the van to remove the tarp. We wish to build a small open carport. We are requesting an exception to the side setback requirement only, as we have more than met the required rear setback. The materials for the carport are already on site and include attractive dark green aluminum panels for the top and standard post and beam construction. I also included pictures that show the old carport and also a picture of the tarp and how it looks. If the right-of-way was simply typical of a tertiary side street in our neighborhood, then there would be no reason for this appeal. The 20-foot setback would have been maintained, and we would already have our carport. We know that the 70-foot right-of-way seems carved in stone, which means it extends 25 feet beyond the edge of our street into our yard, and with an additional 20 more feet of added setback for a total of 45 feet of unusable space in our yard. This is not only unreasonable, it is unfair, and would not be the case for hardly any similarly situated property in Nashville. We respectfully request this exception to the side setback requirement. I'd like to save any time we have for rebuttal.
Okay, any questions, board members? Mr. Ezell? Okay, thank you, sir.
Thank you.
You have some rebuttal time left, I believe. Okay, opposition.
Members of the board, my name is John Michael with the Thompson Burton Law Firm here in Nashville. I represent two different neighbors to the 1601 Shackleford property, Mr. Jason Keckley, Mr. Ray Crabtree, both of whom are here today. I think we'll have you hear from Mr. Keckley in just a moment. Another neighbor, Mr. Harmon Nine, though not a client, did want me to acknowledge that he was here to speak in opposition as well, but just ran out of time today. We certainly understand that happens sometimes. The nature of our opposition that I will explain is strictly from a legal perspective. Number one, having to do with the hardship requirements associated with any variance request. And secondly, the timeline of permits that have been pulled on this property since the Ezels acquired it in approximately the year 2000. To the hardship, bear in mind, you know this language because you see it every single BZA meeting, shall demonstrate a hardship. And then we go through the section there in 17.40, 370. It has the A, B, C, D, E, F. I guess there's those 7 sections, and G, that get into the things that they have to demonstrate. Some of these are easy to demonstrate. Do we think there's a problem with integrity of the master plan? No problem there. Financial gain, the only situation? No, we don't think that's a problem there. They're fine. Harm to the public welfare? That's a bit all Gus, so probably not. But physical characteristics of the property, there's been a fleeting reference to a berm of some sort, but you've seen the photographs from the street level on this. There's nothing at all unique in terms of narrow, shallow, shape, topography, or other extraordinary or exceptional practical difficulty. Yes, including the extraordinary and exceptional practical difficulty that creates an undue hardship to the owner. Undue hardship. Scoot back your parking pad. Park it elsewhere. We don't have much buildable space. You know why? Because in 2001, again in 2001, a third time in 2001, 3 separate permits were pulled to build a new garage, that's April 2001, a 2-story addition to the residence plus a covered porch, that's early July 2001, and then a separate permit to convert a bonus room and attach a previously detached garage, that's later in July of 2001. In 2008, a permit for exterior stair attached to the attached garage, and then in 9 of 2008, another rehab to a duplex use to accommodate that exterior stair. 2015, in addition to the garage for storage only, therefore no addition to the square footage. July 2017, interior and exterior rehab, not really an expansion of the space after an accident to the building. And then in August of 2018, the matter that came to the BZA eventually was for an addition to the rear of the house, getting into the setback variance on Belmont Boulevard that was previously. Well, no wonder there's no room. You kidding me? That's 20 years. Share hasn't had that much work done in the last 20 years, Mr. Bradford. Therefore, I would contend that any suggested hardship having to do with we don't have enough space to put our carport might be more of we don't have enough space to put our car back there. You got a garage, a big one, an expanded one. Therefore, this notion that there are physical characteristics of the property that somehow don't comport with the need and justify a variance is incorrect. There's no hardship there. Similarly, these are not unique characteristics. It is a wide right-of-way. There, Mr. Ezell and I completely agree. However, it's the same darned right-of-way that applies going all the way up Belmont. The rationale that he explained is correctly identified. I've had the same conversations with NDOT. Any of you who've ever lived or worked in the nations have seen similarly wide rights-of-way that are just never retracted back through the years and look like people's yards, not unlike this. You can see the distance between the property line and the road, but it's not yard, it's public right-of-way. And as you can see from the existing carport shown on the as-built plan, you can't build in the city's right-of-way. Can't build anything there. You can't have a fence in there, let alone a carport. The notion that the hardship must not be self-imposed, I think the permitting data that I read off to you there, the failure to obtain a building permit, despite having been through a BZA process, having pulled many permits in the past, demonstrates that this is possibly the single most shining example of a self-imposed hardship of anybody or any case that I've ever sat through. And I've sat through a couple of these cases before. Ultimately, and this is where we want to steer clear of, neighbors being fussy with each other on individual levels, and I don't think it has to be about that. But we're not clean on the no injury to neighboring property. The immediate property to the south is owned by my client, Mr. Crabtree, and his wife. Mr. Crabtree is very limited in his eyesight and is only able to get around by using Uber rides or otherwise getting rides from other people. Even having this driveway that spills out across the property and the big pad that's out there now consistently yields people getting confused as to where their pickup point is when they come to get Mr. Crabtree. Is that the single biggest thing in the world? No. Is it an inconvenience, maybe even rising to the level of injury to a neighboring property? Yes, in terms of the unique needs that he has for that. I've already walked you through the permitting history enough to give you a sense that we do not have a hardship here. The things that we'll finish up with is after all these patterns of trying to maybe build something without the permit or ask for an extension, then ask for a little more, then get the nose under the tent and ask to come all the way out to the property line as the 2018 BZA approval permitted, is just once again trying to this time operate completely without a permit, ask for permission after the fact, have good faith conversations among independent mediators to say, maybe if you just got it within the zoning guidelines, you're clean. You could have done that months ago, or some lesser extension. But no, the request is to go all the way out to the property line after having exceeded the property line and ignore the side setback in this case. The appellant knows all about permits, but skipped it. The appellant keeps changing his situation on this property by building on and building on and building on, and now complaining there's not enough room to build on. Finally, this fails in terms of the process, this fails in terms of what the law requires, and ultimately it must fail at the BZA. These are the legal points that I wanted to make today, and would also like to present to you a testimony from the neighbor, Mr. Jason Keckley.
Mr. Michael, while we've got you, quick question. Do you know the date? Was this right of way? At what point was it? Did the state? Was this right of way dedicated and or condemned?
I do not have a specific year, but it was decades ago. This is not a recent thing. I have no reason to question the exact estimates that Mr. Ezel gave today. This is an old and more established part of Nashville than some others, so it would have been maybe as much as 100 years ago, but I have no reason to doubt the 30s estimate that he gave.
Sir, did you want to, if you'll turn your microphone on and then state your name and address.
Hi, Jason Keckley, 4204 Belmont Boulevard. I live 3 houses south of the applicant on Belmont Boulevard. On our block, the 4200 block of Belmont Boulevard is very small, as you've probably seen from some of the maps. There are 4 houses that face Belmont that are to the south of Mr. Ezel. 3 of those 4 are here today in opposition to this. And we understand that our taste in not liking the way this look is not something that necessarily you guys would hear. However, I would say that this is a corner lot. It has a side setback. That side setback was established to create uniformity, in my opinion, with the front setbacks of our homes. And this does not fall within that. I don't think if I was to come in here and ask for a variance to put a carport at the end of my driveway on Belmont Boulevard, that anyone here would allow me to do that. And I really don't see a difference in that versus what he's asking to do. Furthermore, I would disagree with Mr. Ezel's statement that this is a movable structure. It's not. It has a 3-foot elevated pad that was constructed that's not mentioned. In my opinion, for this to have been in compliance, that would also need to have been removed. You guys have the ability to create more options, which are, A, you can build it inside the setbacks and none of your neighbors will care. You can put your van on your driveway that's got plenty of room to do it and put a tarp over it there and nobody will say anything. Or just don't do it at all. But, I understand that my taste is not part of this, and this is not anything personal towards Mr. Ezel at all. I hate that this is how we're here, but this is not something that I think should be there. I don't want to see it. I think it's rude to Mr. Crabtree. Every day he's at his mailbox, and this thing's sitting right there next to him. And anyways, that's all I have to say.
And Mr. Chairman, the only other note is that I confirmed yesterday afternoon with the property standards chief, Ms. Bishop, who's been handling the case for them, that the case is still open and that whatever comes of the BZA case will be informative to that, but not necessarily determinative in terms of the standing violations that code's still pursuing.
All right, thank y'all. Any questions before they take a seat? All right, thank you. Mr. Ezel, you've got some time left on rebuttal. Did anybody else want to speak besides? I assume that Mr. Michael had talked with the opposition. Do Did you do that? Is there anybody else that wants to speak in opposition?
Not that I'm aware of.
Okay. All right.
Over the last 20 years, my wife and I have had 6 projects at our house. They've been supported and appreciated by our neighbors, except every one of these projects has been opposed by the Crabtrees. I explained why I didn't seek a permit and why I'm building a structure that was drainage problems, which included a 2-sided retention wall to hold back the hill. It was here that we placed gravel as a parking area for our van on top of the hill portion. Codes has previously told me that they had no problem with the parking area. I have only one neighbor, Jason, who discussed with me their concerns, and he said he would prefer not to see the van at all, and that why don't I park it in the front yard? It seems it doesn't matter where I park it on my property, someone's not going to like it. I thought Metro was encouraging homeowners to try and do what we've done and to disguise features such as a travel van. Our travel van is small at 17 feet. It's shorter than a typical Ford pickup truck. We are trying to make the covering for the van as aesthetically pleasing as possible. We think we wouldn't even be here if we had included the carport in our home extension plans in 2018. But we wouldn't be here if this right-of-way was that of a typical tertiary side street in our neighborhood. 4 years ago, this board unanimously approved our permanent home extension in the side setback. At that time, we were given permission to use all of the setback that we needed. That rationale was that the large right-of-way on this dead-end street more than accomplished the city's concern that structures not be built near the street. We believe this request is very reasonable as well. We'll still maintain an adequate setback. Will provide us a safe and attractive way to protect our van, and will add to the attractiveness of our property and neighborhood.
We spoke with the neighbors directly across the street.
Just for the record, I know
April Ezell. April Ezell, yeah.
Okay.
And we spoke with the neighbors across the street and the ones that directly live next to us. And neither one of them were interested in looking at a tarp. They said they were fine. In fact, I think Kathy wrote in and said that she was fine with that. The litany of things that we've done at our house, and one was because a car flew into our house off of Belmont. Flew, literally. Guy went 135 miles into our house. So you're exactly right. We pulled a permit for that because we had to get that fixed as well. It's a 1927 house, and we wanted a bedroom. So I guess I'm a little frustrated because it's been intimated before that there's something about the integrity. We have reached out multiple times to the Crabtrees to try to discuss this very thing with crickets, nothing. So.
Question. Oh, go ahead.
So I had a question. Just that, I'm actually very, very familiar with your property. You have a beautiful house there. I grew up maybe just over 1,000 square feet from here. My parents still live there, so I know this property well. It's beautiful property. I know that on the other side of the house, I think it was mentioned they had a garage over there, and I think it's a pretty big garage, like 3-car garage, something like that. Okay.
Which, by the way, the van won't fit in because.
Okay, that was going to be my question. Why can't you park the van in the garage?
It's too tall.
It's
too tall. Okay.
Yeah, we would love to have done that.
Okay.
My question was, and I'm looking at, this was in the packet. It is, it's a view of the property from Belmont Boulevard and Shackleford Road, where Belmont is on I think it's page 4 of what was submitted. I don't know if we want to pull that up. There's an area, it appears, that is you know.
You mean, I don't know how I'd get the van into that space through our backyard, but that's a greenhouse that's attached to the garage, but behind the house.
Oh, yeah, and I'm thinking of the area that's behind the house and where the words existing carport are.
Yes.
What is preventing construction of something?
It's still within the setback. This is a side setback that we're requesting, and so anywhere I place it along that horizontal line would be in the side setback.
Could you place it where the proposed carport words are there? I mean, is that...
That is where I was describing the issue with the elevation, and that we would need to bring in, 3 feet of fill and retention wall in order to build a way to get the van further back.
Okay. Now, Ms. Weiss, can you go back to the photos? Okay, so just so, I mean, I guess...
Those 2 posts are not involved.
Right. Okay, so I'm trying to just kind of get a frame of reference here, because I know you mentioned the 70-foot right-of-way, so I'm assuming all of that fence that's there, that's inside the right-of-way, is that right?
Yes.
So it's actually further back from there that is where your actual property line is that right?
Yes.
Yes.
That would be correct. The right-of-way extends 13, 10, 15 more feet.
Into towards your house. Okay.
Yes.
Right. So all that's not on your property right there. It's actually about 50. What you're asking for to build is actually about 15 feet back from where those posts are right now on that fence line. Is that right?
Around 11 feet further away than these front posts.
Okay.
So as far as a problem with identifying someone's driveway, I mean, this gravel does not even come out to the road. I don't see how you'd even, the gate, the fence looks like regular gate.
If somebody literally turned, they would turn into a fence. And there's a fence there, and there's trees, so it's clearly not a driveway for... We've barely been able to get the van out to really go and travel all that much. It's not like it's a high traffic situation there.
Any further questions? Somebody thought somebody had their light on. Okay. All righty. Well, thank you.
Thank you.
Close the public hearing and discuss. Can you turn your...
No, I'm just talking to myself over. I'm mumbling to myself, Mr. Chair.
I have a hard... I mean, I understand the concern, or the applicant's point of view of wanting to put their van there. I see that, but also... I don't know if I see a hardship as to not be able to move it back another 10 feet, 20 feet, I think 20 feet setback. So I understand they would have to do some additional drainage structures, but I mean, they have occupied a lot of their lot with impervious surface that affects drainage as well. So I don't know if I see the hardship in moving it back another 20 feet. And I'm still listening, though. I think if someone had other thoughts there.
My 2 comments were going to be, while I don't necessarily see injury to the neighboring property, just kind of based on the photos, I certainly don't think I see a hardship. And so I think, that's where I am. I mean, I'm looking at a lot of the site that's been built. I'm looking at a lot of space where this van could go. Now, I think the van being parked, there's a pad in front of the garage right now. There's space behind the house. And And you know, I've not heard the proof that I would want to be comfortable that there's something physically unique about this lot that would warrant a hardship.
Well, I agree. I don't see a hardship either. So. Motion, say aye. Any opposed? Okay. That motion is, that application is denied 7-0. Thank you all. Next case. Are we on 136, or are we still, is Mr. Cuthbert still in?
That's, yes, I was going to check and see if Mr. Cuthbertson had arrived. Okay, so we'll leave.
Well, we can come back to 136 then.
I'm sorry, we've jumped around a little bit, and so I'm just trying to make sure and find the next one. I believe it's going to be 144. Case 2022 dash, let's see, actually, oh, one moment. -144. This is a request for an additional monument sign at 100 Centerview Drive. This is zoned OL, Office Limited. For you, here's the zoning map for this area. The Red Hatch property is the subject property. There's an aerial view of it. It's a large property, and it you can see where I-40 runs adjacent to it. Here is a photo of the building that's located on the property. And the site plans for the proposed monument sign. And at this time, I'll turn it over to the applicant. If you would please state your name and address. And I believe we had someone else who wanted to speak, which was the reason that this case was being heard. So you'll have 10 minutes to make your presentation. Thank you.
Yeah, is the opposition... The opposition, okay, you're in opposition. Okay, all right, yeah. So you'll have 10 minutes. You'll each have 10 minutes. All right.
Thank you. My name is Jason Morgan. I live at 1220 2nd Avenue North here in Nashville. A little background on Herzing University. I am the Senior Vice President of Campus Operations. We have 10 campuses across 8 states. We are a private nonprofit university focused on nurse education, which is why we chose Tennessee and Nashville in particular due to the demand. We are building out 32,000 square feet currently. And, I'll let my colleagues here speak a little bit more about the signage. But, of course, we're looking to attract students to attend so we can fulfill the needs that our partner hospitals and, and offer the programs that the Board of Nursing has permitted for us. So, with that said, I'll turn it over to Doug Neese.
Hi, Doug Nicey with Collier's. Address is 833 East Michigan Street, Milwaukee, Wisconsin, 53202. I'm the project manager for Herzing on the project, and the request today is for the additional monument sign, as mentioned on I-40. The standards for the variance for this case is regarding the physical characteristics of the property, specifically the exceptional narrowness and the shape of the specific piece of property. So on the previous slide, if that can come up, the zoning map. So the overall site is about 25 acres. The frontage along I-40 is a little over 1,500 feet, but the street frontage that's driving the amount of allowable signage is based on McCrory Creek Road, and that frontage is the very narrow piece that's at the north portion of the map. That's 60 feet in width, so that's the one driveway that goes into this 25-acre site with a couple of 100,000 square feet of office space. That's driving the limitation to the number of signage and the amount of signage on the site. In all senses, the building's experienced on I-40 over 1,500 feet. So our request is to have one more sign, monument sign on I-40, the same size as the existing sign that's been there since the building was built.
We would like to reserve the right for rebuttal.
Sure.
My apologies.
So as I understand your hardship, it's that you've got a lot of perimeter, but you've only got 60 feet of frontage that's on what is based the sign limitation.
Correct. Exactly.
And
yes.
And part of that is that I-40, as I recall, that's parallel, or is that there? It's a main artery right there. Which one is that? And the sign is on.
Just so I'm understanding what you've said correctly, the street that's if you're coming away from Stewart's Ferry Pike.
Yes.
That's the street that the frontage is based on that
Correct.
Enters into the property?
Correct. The very narrowest point is 60 feet per survey.
Got it. Thank you.
And just to be clear, your sign is not going on that frontage, it's going on the I-40.
Correct.
Frontage.
That's correct.
My name's Mike Shea with Jocelyn Sign Company. I've got a better picture that'll show you placement of the sign.
Okay. Thank you.
And while you guys are still up there, I did want to verify, this isn't like a motion sign or anything like that. This is just it's lit, but it's not a LED
Correct.
Changing.
Correct.
You can see in one of the pictures the existing sign on I-40.
So there is an existing sign.
There's an existing sign on I-40, and this one will go 100 feet to the east of that sign.
Okay.
The existing sign by law could be actually increased.
Okay.
The codes would allow that. Herzing would like their own sign.
Okay.
It's the same type of sign where the background does not light, only the copy lights.
Okay.
The sign
So Herzing's not using the entire facility. That's why you want a separate sign.
Correct.
Okay. Gotcha.
So this won't be a sign for your institution. The names that are up here looks like a number of tenants. Y'all will not have your name up there.
Correct.
Okay.
Separate sign.
You're not going to have two signs right by each other with your name. All right. Gotcha.
Is the sign that's there now, are those tenants still there? Is that sign going to stay?
That sign's going to stay. The tenants may be exactly as the ones in the photograph or have changed, but that sign remains. It's an additional sign that we're asking for approval for.
Okay.
So the new sign will go in front of that big for lease sign that you see on the next to last page. And yeah.
Okay, thank y'all. Well, you have some time left on rebuttal.
Thank you very much. Thank you.
Hear from the opposition.
Good afternoon, ladies and gentlemen. My name is Judy Maloney. I live at 3256 Niagara Drive. I have been there 42 years now, and I represent my Waterfalls neighborhood. Our houses back up to I-40 interstate, and we have a lot to deal with the interstate, with people breaking down on the interstate right behind our homes. We did not have the luxury of having any type of sound barriers put up, so we have nothing but whatever little fence line gets put up beside an interstate that keeps the deer from jumping over it and getting into the traffic. I would like for it to be known that this request to have another sign has already been denied by, I believe, you all. And this is their second attempt to run through to have it put up again, and it has already been heard. The Hertz University have already got a sign on I-40, as you all well know, but it's not, it's Argos or something right now, Argos College, and it's on the side of the interstate going toward the airport, going to downtown. My concern of my neighbors is, why is that? If you already have a sign going in, if you wanted another sign, put it on the other side of the interstate so the people going out who would get off at that exit, Stewart's Ferry exit, could parlay it. The lights from
Is that like a billboard sign, or is it on the property? Is the sign on the property?
It's a sign that's on the property now.
Okay.
That's already there.
Okay.
We're only talking about 100 feet apart. I don't know why it's not on the other side. If you're trying to get business to come to your college, you would have it on two sides of this interstate. We also had members check the other colleges that are in Nashville, of which we have plenty. None of them have 3 signs advertising where they are located. I think this is overkill. We don't need not one more sign for us to look at as on the interstate. I'm afraid to say that. We do not need any signs that are shining any more light into our backyards that is already there. Is the sign going to be on all night long? People break down on the interstate. They're already hopping in the daytime, hopping over that fence, wanting to come over and use gas cans from us. They want to call on the phone because their cell phone has died. And that's a dangerous situation. We don't know these people. We don't know who's hopping over the fence. We've had lots of vandalisms of people who have hopped the fence or had come up the street, stolen from us, and jump over and have somebody on the interstate waiting to take off with whatever that haul is. And if this is at night, this is putting us in danger of more people. They'll have light to see where the fence is and where they can hop over, and they can test it out and look before they ever get to our house, their exit route or their entrance route. And my neighbors have signs, which the city has already set down the laws and the request that it not be put up any more signs up in our area. And I would like to thank you for your time and consideration of our opposition to the sign. Thank you.
Thank you, ma'am.
I had a question.
Ma'am,
I did have one question.
Hold just a second.
Yeah, I have a question if you don't mind. You're fine?
Forgive me, I'm sorry.
So is your primary concern, is one of your concerns, you mentioned one of your concerns is over the light. If it was not an illuminated sign, would that make you less opposed to this sign? If it was just
I think it's too many signs.
Okay.
I think it's people trying to read too many signs going down the interstate will probably cause wrecks to happen.
Okay.
I don't understand why they can't build either higher up or change the type of sign that includes both names of those places. I think building another one is not cost effective and not going to work for anybody but them, but that's okay.
And can you, I may not have been completely following your train of thought there as to how the sign affects people from the interstate coming into your properties.
The light from it is what I was saying.
Okay, I got you. Okay.
Yes, sir. The light from it. Yes, sir. And in the wintertime particularly. I mean, it's really bad in the wintertime. There's no leaves, trees, anything.
4:30, it's dark, yeah.
Yes. Yes. And the darkness comes even sooner.
Ma'am, just so I'm clear, this is on the, this property is on the eastbound side of I-40?
Mm-hmm. Mine?
Yes. Yeah.
No, I'm not. I'm on the east. Yes, I'm on the westbound side. I'm not where Cracker Barrel. I'm opposite of where Cracker Barrel is.
Okay.
Yes.
Got it.
Mm-hmm.
Okay.
The sign is very readable. I mean, the one they have up now.
That's it. Thank you.
Yes, you may turn your microphones back on it for your rebuttal period.
Okay, great, thank you. My first time doing this, actually. As an educator, I always encourage constructive discourse, but oftentimes, we want to encourage on what's facts. We currently don't have any signs. We've never applied for this, so unfortunately, I won't be able to, refute those for that. I'll let my colleague talk more about that, but I just want to make sure what we were talking about. We're not Argosy University. There is an old sign from a now defunct university, but that's off the exit. The green ones that you can get for government educations. Not this, but it's not us.
Just to add to that, so this is the first time that Herzing's been in front of the BOSA. We had no application before, had no denials before. This is our first request. We asked for the approval. The sign that we're proposing is not unlike the other sign that's there. It's internally illuminated. The majority of the sign is a dark blue Herzing color, and Herzing, the name itself, will be the piece that's white, and maybe the imagery that you have shows that. One of the signs, it's not intended to let off a lot of light, and certainly wouldn't illuminate more than a few feet in each direction.
It is, as far as relevance, convenient for our students. We serve a lower socioeconomic population. Over 80% of our students are female. 75% are minority students. We'll be pulling from all areas, bringing in, to this area to help that. Oftentimes, getting to school right on time and understanding, where the university, letting our partners and communities know. As a nonprofit, we're very proud to serve our communities and partner in doing that. And this will help us, be successful here in Nashville and Tennessee.
Any further questions?
Is there some reason why the other sign is staying up there? Do you still have the tenants in there, or are you taking the whole space down? That's understand that part of
has signed as one of the largest tenants within the space, and so as part of the discussions with landlord, the landlord has offered, based on your acceptance, to have this additional sign there because of the significance of Herzing's investment in the location.
Okay, so as a tenant, though, you would be entitled to have the name of the university on the other sign also, if you wanted it, or are you just going to have? I'm seeing the shaking of the head going back and forth rather adamantly. So
it'd be duplicitous, and with that, and it's just the one sign.
Okay.
I had a question, and it might be that, and I apologize, I forgot your name, from Jocelyn and Son Signs, the representative. Yeah. What's the approximate distance that the light would extend out from the sign?
I don't have that data in front of me, but it wouldn't be like a beacon if that's what you're talking about. I mean, I can get you the foot candle power that it would emit, but it's not going to be.
Yeah, I think my main question is, kind of given the location, is it close enough to where there's going to be light infiltration into the neighborhood nearby?
Absolutely not.
Okay.
Do you know, and I can ask our zoning administrator, how much more road footage would you need to have sign 3? You've got 60 feet, which limits you to 2. Do you know how much more you'd have to have before you could get to 3?
Codes has a nice big chart for that,
which I printed out.
It's got a lot in there, so
the existing sign could be made taller and larger.
So this is OL district. Yes, correct.
Okay, and you got 60.
Correct.
Okay.
What's I-40 frontage? That's like
I-40 frontage is 1,549 feet.
It's got one sign on it now, and
but you can't count I-40, right? That's your problem. Is you got to count the 60
feet. Correct. That's exactly right.
So it'd be required 400 for 3 signs. All right. Okay. Thank you very much.
How much additional signage is allowed on the existing sign? Like what's the delta between what you have and what's allowed there?
I had that calculated out many months ago, and
again, under the
quite a bit.
Under the current frontage, under OL, it would be 40 square feet total.
Okay.
The 2007 sign was under a separate BOZA approval, I think from 2007.
Okay.
And I believe the number was, and I'd have to confirm this, about 192 feet or so.
Okay. So total allowable.
Total allowable. Yeah, that was my recollection, but I can confirm that.
And what square footage is the sign that you're proposing here?
The same size as the current sign, which is approximately 12 by 12 or 144 square feet each.
Okay, so like the total of your existing sign and this sign would be greater than what was allowable under that previous order. Even if you enlarge.
Place it with a bigger one.
Right, yeah.
I mean, I see that could happen, but that's just seems like a waste of resources and concrete and metal and plastic.
Okay.
In looking at one of the pictures that's up there, you've got the one in the lower left. There's a gap there. Are you going to run messaging underneath there, or are you just going to have the name of the university?
Just the name and static backlit.
Okay, so you're not going to have false Mr. Stars volleyball season begins.
And, you know what, we take that into consideration. We were talking about that, earlier. As I said, it's somehow something digital would get beyond me, unless it wasn't.
Well, and I just wanted that clarification, because looking at that, that's exactly what it looks like you could have had, and I didn't think that's what you'd been saying. So I wanted to make sure.
They were trying to replicate that black shading. I absolutely appreciate where you were. It's not going to be static.
Okay, thank you, sir.
Would you be opposed to having a non-illuminated sign? I mean, I know obviously you like the sign that you have designed, but hearing the complaints about the illumination, and is that something that y'all be amenable to? Or would that create more illumination if you're like uplighting on it, I guess? That's kind of the question I'm trying to get to.
Yeah, you're right. Actually become almost like a beacon if you shine light at it.
And certainly we wouldn't want to do it as if we're out of business because
one internally illuminated, then in the other 100 feet away from it be floodlit.
Okay, any further questions? Thank you, gentlemen.
Thank you very much.
Thank you for materials. Can you put up the, yes. No, ma'am. Can you put up the parcel viewer again so we can see the shape of the, okay. I mean, to me, it does seem like it has an exceptionally very limited amount of road frontage for a 23-acre parcel.
I never remember this coming before us.
I don't remember it either, and I think I would have remembered it. Yeah, I don't.
You're the old one.
I don't remember it. It doesn't mean it didn't, but I don't recall it.
I wasn't around here.
I think I do see a hardship in the unusual shape of the lot. I do hear the neighbors' concerns, and I think that it's obviously a very important thing to them. That's why they showed up here and voiced their opposition. I think I have a hard time seeing how the addition of this sign would negatively impact their neighborhood. But I'm definitely listening to what others say.
Yeah, I have a hard time seeing that too. I understand they're concerned about it, as neighbors always are when something happens, but there's a lot of space there. And that looks like a pretty big right of way, and I understand their concern about it not being illuminated. It would look, and it's not a flashing sign. It's what would we call it? It's LED.
I know we've had these in the past where it's like a billboard that changes every 30 seconds or something, and that coupled with the testimony that we heard that the light wouldn't reach the neighborhood. I'm inclined to support it. In fact, I'll make a motion that we approve the variance as requested due to the physical characteristics of the property based upon the limited road frontage as compared with the size of the lot and the unique circumstances.
Okay, there's a motion to approve the application and a second. Any further discussion? All in favor, say aye. Any opposed? Okay, that passes 7-0. Thank y'all, both sides, for speaking. Next case.
Okay, yes, sir. Just going to run through my slide deck to get up to speed. Case 2022-147 is a request for a special exception to allow for an addition at an existing church at 901 Acklen Avenue, zoned R8. This is the zoning map. And some photos here of the existing structure, as well as the streetscape. So those are the homes directly across the street there below.
Let me confirm, is this the one we had opposition to? Okay, so both sides have 10 minutes since there's opposition.
Yeah, and we'd like to reserve the 3 minutes for rebuttal.
Okay, we'll reserve that for you.
Okay, I'm Mike O'Kelly with O'Kelly Architecture. We're at 17 Mount Laurel Avenue, Birmingham, Alabama 35242. My firm's obviously the architect of record for the project, but I'm going to let Philip here do the presentation, but I'm available for any questions related to building design.
And I'm Philip Piercy with Catalyst Design Group, 5100 Tennessee Avenue, Nashville 37209. This project is, of course, an existing church that we're making an addition to. It's about a 17,000 square foot addition. The addition that Michael can speak to if you have any questions, but it's mainly for educational space and kind of more of an greeting area and administrative area. There's no proposed expansion of the sanctuary, and so no anticipated increase in seating from the existing church that's there. The addition was go out into the existing parking lot, but we've kind of redesigned the parking lot to maximize it, and we're meeting the metro parking requirements that are currently in place. We sent out about just short of 500 notices to neighbors and had a neighborhood meeting a couple weeks ago where it was attended by two neighbors, the one immediately to the west of us and the one immediately to the west of him. Had good discussions with them, and their main concern were a couple of things. One, the immediate neighbor wanted some landscaping along the common property line, which we were going to provide. They had expressed concerns about the lighting, to make sure the lighting in the parking lot doesn't go over into their yards. And so the lighting will be new lighting, parking lot lighting installed, and those will be updated fixtures that will direct light into the parking lot, and would be on a timer to cut off at late at night. They expressed concern about parking, which I noted we meet the parking requirement. Of course, we acknowledge there'll be some parking on the street at times, but with the church, the main use is on Sunday morning. There are occasional Wednesday night services or Sunday night services, and maybe even small groups on other nights. But the bulk of the parking would happen only on Sunday mornings. It's typically considered a low traffic impact for a church. The other concern they expressed was just the speed of the traffic on Acklen. Acklen currently, this is all existing condition before we're operating there, done any additions. But Acklen, I guess, is kind of a cut through. I don't live in the neighborhood, but obviously the neighbors are familiar with it and have concerns where people cut through there and with excessive speed. We're certainly not contributing to that problem now, and our addition will not contribute to that issue. So we don't know that there's anything that we can do about that, but certainly understand the neighbor's concern. As Michael said, we're here to answer any questions you may have, but otherwise.
Yeah, just to reiterate what Philip said, we're not adding any additional worship seating. We're actually taking some away. There's two existing side balconies that we're actually going to get rid of because the sight lines are so bad. And then the entire proposed addition you see there, it's pretty much everybody on that side of the facility doesn't drive, so they're not parking. Those are for kids. There's preschool downstairs and children, elementary school children upstairs. There'll be a few staffers or volunteers that, monitor those classrooms, but the sole purpose for the addition is strictly classrooms, and then to give us about 4,000 square feet worth of lobby space, just places for people to hang out before and after services.
How many services on a Sunday does the church anticipate to have?
Typically two.
Yeah. With a small group time kind of alternative. Okay, thank you.
school area is not anticipated to be a five-day a week.
Correct. Yeah. It's not a
during services or.
That's right. It's not a Mother's Day out or a weekly preschool program.
How many?
7 classrooms total. Is that what you're asking?
Well, I was going to go, how many kids is the wrong word. How many children are you anticipating participating in the program?
Yeah, at the size of the classrooms, they would accommodate 18-ish kids times 7. In a real world, maybe that's closer to 13 to 15 times 7.
Y'all have any other questions for us?
No further questions from us, so you'll have at least 3 minutes, I believe, left on rebuttal.
Not so much opposed to the addition, but maybe the addition, what that does to the parking. Obviously, that was a concern of some other neighbors. And the point he made was Acklen Avenue is a very dangerous street. It is a cut through. I've personally had a vehicle totaled because of somebody speeding down the street, losing control, hitting it. There's a crosswalk directly in front of this church across Acklen Avenue that I use probably 4 times a day as I walk my child to school. Nobody ever stops there. I can sit there and count 15, 20 cars driving by who just don't pay attention. So again, not so much opposed to the addition, opposed to not having any mitigating factors as far as traffic and what the parking or lack of parking is going to do to people parking on the street. It's going to go down the street. People are going to park in front of the crosswalk. You can't see. A couple months ago, I guess, sent a survey or whatever to NDOT about, traffic calming devices in the neighborhood. My desire, there's a big intersection there, perfect place for a roundabout to slow traffic down. So just as residential developers are required to put in sidewalks, I feel like in this case, somebody other than the city and myself as a taxpayer should bear the cost to put some traffic calming devices in the neighborhood as part of this. That's all I got.
Are there any blinking lights or anything like that in the neighborhood that would?
No.
Okay, I mean, for you,
they don't matter. I stood out here crossing the street and 30 cars drove by with a blinking light on 2nd Avenue or 4th, whatever it is, right out there. So,
understood.
It doesn't do any good.
Yeah, understood.
You put in some speed humps or a roundabout, people will stop.
You don't have a whole lot of choice sometimes.
Yeah.
As someone who successfully led a campaign to get traffic calming in my neighborhood and on my street, I certainly hear your concerns, but I think I know that there, like you said, there are programs in place. I don't know what our limits are as a board to institute things outside the right of way or outside.
I don't believe it's within our authority to do anything on that front, but I will just state that I've obtained traffic calming for my neighborhood and would recommend reaching out to NDOT and council.
Yeah, I have. It's
I would be surprised if even the church opposed the concept of traffic calming, given the number of children that are in the area either. So,
right. And I guess another question too. Maybe I just am confused. Is this addition? Is it school? It sounds like there's a school, or it's not a school. I don't know. What's the deal?
So what was shown in our packet and the plans that doesn't show on the screen here, but it looked like there was some preschool space, children's small group space, maybe some pre-function space where people gather before going to the church service or vice versa, some restrooms. But as the applicants noted, didn't include include any additional space to their sanctuary or meeting house kind of space. So.
Any further questions for this gentleman? Okay, thank you, sir.
Thanks.
Okay, any further questions? All right, thank you, gentlemen. We'll close the public hearing and discuss. This is a special exception, and so, as we know, if they meet all the criteria, which they do, we have to approve it unless there's credible proof of some kind of effect to property values or injurious to the neighborhood. I understand that the opposition's concerned about the traffic issues, but I think for us to act on that, we'd have to have something other than, we'd have to have a parking, some kind of traffic study done by the HOA or something other than those kind of generalized concerns.
Yeah, I mean, there's definitely going to be more car. I mean, this is the opinion of one person that I probably, but there is not enough parking on this lot to carry all the people that are there. And part of that's because our minimum parking requirements that are going away, apparently. I mean, they have one car for 4 people for a church service. And, the average for a church service is 1 to 2.5. So our parking code is already kind of lower than what actually happens on that typically. So, I hear his concerns. I hear the neighbors' concerns. But as you mentioned, this is a special exception, and it seems to meet the requirements of a special exception. I hope they do get traffic calming, though, because I could see how that could be a big issue along that street.
Well, I'll make a motion that we approve the application. There's a motion, second. Any further discussion? Okay, all in favor? Aye. Okay, that passes. Thank you, both sides on that one.
Next case 2022-148. This is a request for a special exception to permit a large daycare home at 1531 12th Avenue North, zoned RS5. Here's a zoning map of this area. Aerial view of the neighborhood, the subject property. Just some closer views of the fenced area. One of the requirements is to confirm that the outside play area is completely fenced in, and so that was one of the factors that the board would consider during its deliberation. And here is the site plan submitted by the applicant. At this time, would ask that you come forward. Please state your name and address. And is anyone here in opposition to this case? I don't believe so. And so, ma'am, you'll have 5 minutes to make your presentation.
Hello, can you hear me? Hello, my name is Felicia Blake. I reside at 1531 12th Avenue North, 37208. I am requesting to have an in-home child care with 12 children ranging from the ages of 6 weeks to 5 years old. It will be licensed and monitored through the DHS rules and regulations. My hours of operation will be 7 to 5 p.m., Monday through Friday. That's all I have. And as far as fencing, that will be completed on November the 21st.
The fencing?
Monday, November the 21st.
Okay, so and that's before you'll be open?
Oh, yeah, I still have to go through the licensing process.
Okay, gotcha.
Yes.
Yeah. All right.
Just some quick questions for you. On the special exception provisions require just verification that certain things have been met, and it's an occupied residence?
Yes, I live there.
Okay. Understand. Minimum lot area is there.
I can confirm that the minimum lot area has been met and the 100 feet from the terminus of the street. Yes, sir.
Got it. Are there any other daycares within 1,000 feet?
No, it isn't.
And you indicated that the outdoor play area will be fenced in on Monday, the 21st?
The 21st,
What's the nature of the fencing going to be?
Well, it's already fenced in.
Okay.
It was just, I just have one granddaughter, so the backyard is already fenced in. It's like on the side, it's like one little.
And it's a wooden fence?
It's wooden fence,
Okay. And you've indicated you've applied with the state?
Yes, I have a specialist. Her name is Rachel Raquel.
Okay, and you agree that you'll continue to operate in conjunction with the state's requirements?
Correct, yes. No other way. I wouldn't be here. Yes.
Any further questions? Okay, thank you, ma'am. We appreciate your time.
Thank you.
Well, y'all are probably asking, why is this not on the consent agenda? And I think we...
That was an obvious question,
well,
but I was not going to ask it.
It was, well, maybe it should have been, so I'll just say that. So, I mean, they've met all the, there's no opposition here. They're entitled to this. They've met all the requirements. So I'll make a motion that we approve this one.
A second.
Motion and a second. Any further discussion? All in favor? Okay, approved. Yep.
Case 2022-149 is a request for a street setback variance for property located at 6604 Ellsmere, zoned RS40. There's a zoning map of this area, residential single home properties, and then this is the aerial view. There's a front view of the lot, and another try to depict some of the issues that have been brought forth by both the applicant and the parties who've spoken against this request. This is a copy of the slope map from ArcGIS data with Metro, and you can see where the areas in red have a slope of greater than 25%, and then the lot, the subject lot, is sort of in a darker red color just because of the way that the program was highlighting it, but it is an accurate depiction of this slope. And then this is a bigger picture of that area and the slope, because I know there were a lot of comments that spoke to the question of the other properties and how they were outlined with respect to the slopes on their various parcels as well. And then this was the site plan that was submitted. And is there anyone here to speak against this request? So, sir, you'll have 10 minutes. And if you'd like to reserve some time for rebuttal, please let us know. Please state your name and address before you get started.
Hello, my name is Michael Elliott. I own and operate Elliott Development. My address is 3844 South Mount Juliet Road, Hermitage, Tennessee. I own and operate Elliott Development with my father. We own the land at 6604 Ellsmere Road. As you can see, it's just it's currently just a vacant piece of land. Requesting a front setback variance, very simply, and just to keep it short, the hardship is just simply the topography. We would like to bring the house down the hill to essentially be able to create one more of a backyard, which would actually be accessed off the second floor, and then more of a level front yard, as well as a driveway that wouldn't be a ski slope. So pretty cut and dry. Just would like the opportunity to make the lot work and, be a little bit easier on everybody. So if you look at the lot to the right, the setbacks that we're shooting for compared to the existing house would be a little bit in front of that one, but what the contextual where it has us now is actually even tucked up higher on that hillside, which is just going to be, it's going to be a tough one. So would love your approval and your help with this one. Thank you.
Before you go, I think you may have a question.
Yeah, you mentioned the house next to you. It looks like that's about 105 foot setback on that, and your contextual is 120 feet almost. You're asking for 80 feet. would you be able to build a house at the 105-foot setback?
Which would be, are we talking kind of in the middle of the two? Is that what you're asking?
Yeah. I mean, you're like, yes, that'd be 15 feet in front of where the contextual line is, but it'd be even with the house next to you.
Anything will help at this point in time. I'm would love the opportunity to, to just make something work, I guess is what I'm asking for. If that's what it takes, that's what it takes. But, we'd love anything at this point in time would help.
Can you kind of say, more what the hardship on building on a steep lot is?
Yeah, so, one, I bought both pieces of property last year, sold the house to the existing house on the right to another developer, and I own a separate company. I do foundations and concrete. So I ended up hammering and just blasting out rock behind that house to create the addition that they wanted to do on that hillside. So I know exactly what I'm getting ready to get into when tearing into this one. So, it's just a tough lot. As you can see where my house is, those lines are a little bit tighter, and obviously the elevation increases the higher you go up. But on my lot, it's a little bit higher than where that one sits right now. So very simply, it's a hillside lot. We're going to have to do a bench cut. The smaller the cut, the easier it is. And obviously, we're wanting to create more of just a nice, clean front yard, a usable backyard. And then, we're even open to, if you guys would prefer, a driveway that would kind of cut across the lot and in the front instead of just a straight shot. That would give it a little bit more appeal as well.
Okay. You've got some time left for rebuttal if you want it. So
I'll take it. Yes, sir.
You'll have an opportunity to come back up and address anything that they say.
Thank you.
Diane Schwartz. I live at 6605 Ellsmere Road. I'm directly across from this vacant lot. My name is Catherine Barsoon. I live at 6608 Ellsmere Road, which is the lot directly adjacent to the one in question here on the left. So I have...
When you say directly adjacent, do you mean the one that is...
The one that's in the photo.
The one that's built in, okay, all right.
Yep.
Okay.
I know that you guys have the aerial, but this I just pulled off of Google. I guess my concern here is that the houses on that side of Ellsmere are set back. And it seems kind of odd that the house in the middle of two houses, or it's the vacant lot in the middle of two houses that are already built, is claiming that it can't be built or that there's a hardship there. That makes no sense to me. I think it's pretty clear that there is a flow of those houses on that side of Ellsmere that, based on the aerial photo that I have there, that by building this, I think he was requesting to build it 80 feet as opposed to the 119.8 would just make it stick out like a sore thumb. These lots have large front yards. That is the beauty of Westmead Park. That's what it looks like. And that is, these houses were built in the 1960s. They don't really have a lot of backyard. There's a lot of these yards have woods behind them. This one also does. But the flow of that neighborhood, or of this neighborhood, is the large front yards. They're in the 119.8 foot setback. I find it interesting that what I was able to see in the application, they list and they put the house to the right, but they don't put the house to the left, which is the house that this lady bought, which is, it seems like even further back. So again, I'm not quite sure why there is a hardship on this particular property that's in the middle of two houses that are already built. And if a variance is given to this one piece of property, it's unfair to these other properties that complied back in the 1960s. I'm sure the equipment has gotten better, and this, I mean, it can be, I believe it can be done. I believe I've received a lot of notification from others in the neighborhood that feel the same way, and that this will stick out like a sore thumb if it's pulled forward as they have requested.
Pam, can I ask you a question?
Sure.
How do you feel about, and I would like both of you to answer it, how would you feel if the house was brought in line with this young lady's house, like if it was the same as her house?
That would, I mean, then it would contextually look like it.
Contextually, it would land in between the home that he sold, the lot on the right, 100.
So that's not your house on there. You're on the other side.
No, I'm on the left.
Okay.
Yeah.
Okay.
Okay, so you're the deeper one.
I am the deeper one.
That's what I needed to know. Thank you. So then you wouldn't, how would you feel then if it was the one that
was jutting forward?
Yeah, a little bit. Like Mr. Newton sort of proposed a compromise. How would you feel about that?
I think as long as there's a linear, it doesn't protrude in front of the existing home, not the driveway, but the home that's been remodeled on the right, that would be much more in line with the neighborhood aesthetic than proposing the 40-foot gain at the front. It would legitimately jettison and be the oddball on the street. I personally waited 2.5 years to get into this specific neighborhood for the lots and for the zoning requirements that have been upheld within Westmead Park, not just Westmead, but Westmead Park specifically. Myself, I do not have a backyard. I have a steep hillside as my backyard that is fully wooded. My next neighbor as well. I've walked both lots, didn't mean to trespass, but just out of curiosity. And in my 7-month pregnancy, I do find the slope in front of the lot in question actually much easier to walk. You can walk on a straight line, whereas I'm struggling up my curved driveway to make my mail check every day. So in comparison, I wish I could show the depth, but immediately upon our property line is actually where the terrain of my lot jettisons upward quite significantly. So my lot actually looks over and down towards these two lots that you see. Kind of think of those two lots as like the slope towards the end of the street for perspective.
That was helpful. Thank you both.
Well, and I'm not discrediting when you're walking across, but when I look at the topo, this lot does stand out like a sore thumb in terms of it is topographically different. The slope, at least what he's concerned about.
And what you'll notice if you go back to that topographical map, my home was excavated to sit on what is considered that little yellow bar was excavated so that the home could sit there. I have severe
So where there's the cutout in this kind of.
That's correct.
Your home was excavated there?
Yes. So you'll notice my front lawn is actually the steepest on Ellsmere Road, and then the hillside behind me, I don't have the luxury of a backyard, is equally steep. So my home's been excavated to sit right there.
And forgive me, you indicate your home was built in the 60s?
1962.
Okay. Has the lot next to you, how long has that lot been vacant? Do you know?
For the conception of the neighborhood.
It was my understanding the person who owned the house that has been the one that he was referring to that's on the right, that person, I believe, owned it and was going to build on it, maybe build something for his mother, and never did. So he then sold both of these lots. And then I think one was sold to another developer, and then this gentleman is wanting to develop this land, which has been vacant. And I've lived in this neighborhood since I was 6 years old. I didn't live at 6605. I lived on Clearbrook. But this neighborhood is very interesting. It has a lot of dead ends. It has a feel to it. It's called Westmead Park. It has a park-like feel, and thus this request just seems out of sorts with the way these other homes are on Ellsmere.
Any further questions? Okay. Thank y'all very much.
That's okay. Thank you.
First and foremost, thank you for your comments. You both have beautiful homes.
Thank you.
As discussed, as what the lady here on the left said, I never said it couldn't be done. It can be done. And as mentioned, the lot is just, it's steep. And again, as you and I discussed, if any kind of allowance we can get, that's kind of what we're shooting for. Did I expect to get the full 80? Maybe not, but anything will help at this point in time. And I will just, I guess last note is the surveyor, we weren't trying to hide anything by leaving the house off on the left. I was given the information that I was requested to get, and I believe that setback, mine being deeper than the one on the right and past what the plat requires, is because of that house on the left. So just to clarify that, I didn't want you guys to think we were trying to hide anything with that. So I think that's it.
Just looking at the map too, it does look like it's on a bit of a curve. That I'm assuming that has some impact on the angle. I guess you're trying to build a house with the slopes, with that curve, and trying to kind of work it with that.
Yes, sir. I didn't mean to interrupt you. I'm sorry. But essentially, we're wanting to do a bench cut, as she said. Basement on the first floor, second living above. The retaining walls with this house off that back basement wall are going to have to go back into the hillside just to create any kind of usable space back there, which obviously it's going to be minimal, but something. It's speaking to them without looking at them. We're here to bring a quality home. I'm not an investor from California that is getting these things up as quickly as possible. We're here to build a quality home and do a good job and want to treat everybody how we'd like to be treated while doing it. So,
approximately what depth of the house would it be? Because
I'm sorry.
What depth would the house be? Like from the front of the house, whether it's whatever setback it is, what depth are you trying to build on that?
Well, it's going to be, the first floor would be 10 foot ceilings. So with,
depth,
the plan should have been on there. I'm sorry. It's 29. The first floor is listed as 29 feet deep.
Okay. Thank you.
So you've got anyways, yes, sir.
Any further questions? Okay. Thank you, Mr. Elliott.
Thank you.
Appreciate it. We'll close the public hearing and discuss.
Cool. I wanted to ask about the depth because, we've heard other cases here where it was kind of like, it can be built, but, but then we'd have to build a smaller house. But, 29 feet, it would be in keeping with the kind of consistent pattern of the 1960s neighborhood. That's pretty typical for a ranch house kind of depth. So that does seem appropriate for the neighborhood.
So I think that if you look at the topo, it is there. I think this lot is steeper than some of the others. Now, I don't know. A good point was made about a lot being excavated, and it doesn't look like anybody's got a backyard. But I look at this picture, which is very helpful, and I'm empathetic to the developer builder, but it just seems to me like it's a really nice alignment of homes, and if you have one sticking out there, I think it is going to be aesthetically, I think it's going to affect the look in a fairly dramatic way, in my opinion.
was going to make a motion that split the baby here and move that we grant a variance of I believe a variance of 19.8 feet that would get us to a 100-foot setback, which would effectively be the midpoint between the contextual and what the applicant has requested based upon the physical characteristics and slope of the property.
So you would, a 20-foot variance is what you do.
Can I ask a question? Is that going to put him in front of the other neighbor who came? So that's.
That
was my only question.
I think the neighbor. I think it would put it like 5 feet in front of the neighbor who didn't come, because the neighbor who's with us is actually further back. But I think the question is the house to the left is at 105 feet. I believe was what was.
What if we did it at 105?
That's what I.
Would that be acceptable to your motion?
So the 105 would be even with this house here.
Yes, correct. I'll second that if you're good with that.
I'm just trying to split the difference between what's there and what was sought.
Chancellor Bradford?
Do I accept? Yes, I'll accept the 105.
So there'd be a deviation of about 20 feet or so?
14.8 feet.
And y'all are pretty convinced it'll keep it lined up with this house here?
That's what I was worried.
I'm all for compromising, but I do think the aesthetics I don't want to compromise just to compromise if it's going to make these houses look not aligned.
I don't think, especially with the curve of the road, I think it'll be appropriate for the neighborhood characteristics.
So there's a motion and a second. And the motion is to allow a 100 and...
It'd be a 14.8 or 14 foot
variance to 105 feet from the...
Yeah, to allow construction at 105 feet.
Okay. All right, that's clear now.
They'll be right here. I draw things.
Drawing early. Yeah, is what we were thinking.
Yeah. Oh, okay.
Yeah.
Okay, there's a motion and a second. Motion and a second. Any further discussion? All in favor? Aye. All opposed? Okay, that passes 6-5-0. Thank you all both.
Good, thank you both.
Okay, next we have case 2022-153. It's a request for a special exception to reduce the side street setback along 55th Avenue from 10 feet to 2 feet to permit the proposed construction of 2 additional residential dwellings at 5501 New York Avenue. This parcel was zoned, this specific parcel is zoned MUN, although it's actually in an R6 zoning district. Here's the aerial photo of this area. It's close to Centennial Boulevard if you're familiar with the Nations. This is the subject parcel, and so 5501A is going to be the home on the left, the 2 HPR homes. Obviously we're built together and look similar, but it's actually the one on the left. And this is kind of what the house looks like as you go along toward the backyard, along 55th. And then there's another view from the opposite side of the street to get a sense of what the rear of the parcel looks like currently. A view of the streetscape there along New York. And the site plan. Is anyone here to speak against this one? Yes, we do. And so, sir, you'll have 10 minutes to make your presentation, please. And please state your name and address and let us know if you would like to reserve some time at the end.
Hi, my name is Chance Alford. I am the builder for the owner of the property.
Can you state your address, please, sir?
My address is 1574 Foxland Boulevard, Gallatin, Tennessee. My partner purchased this property as an Airbnb investment property with the option to build another dwelling behind it. I questioned the approval of the building behind it, but from the buyer, he had proven documents of this dwelling, and there had already been a BZA approval on this exact. We're not doing anything different that was already approved previously. The only thing that happened was the previous owners did not permit the property in time nor build it. Their connection within the planning committee, they submitted a letter to my partner on this, stating that, the BZA was approved, that, it just needed to be resubmitted, that everything was going to be okay, that he would. I questioned it. Now, once I saw all the paperwork that it was approved, that it had already been approved, the only thing that has changed is that it just expired. From my knowledge, no houses have changed around it. Everything is exactly the same, except for the Silo Bend community across the street that had been built, which is a townhome community, and basically made us send out an extra 300 letters for this BZA meeting. But other than that, nothing has literally changed in the development. So it's pretty cut and dry. He bought it because it had the approval already. They sold him on it that it would already be approved. We just had to go back through the motions because it had already been approved and all this had already been granted. So that's really all I have. I mean, nothing's really changed.
Any questions from the applicant? Okay, so
let me make sure. So there's an existing house on the same property, and you're trying to build two more houses on that same, or two more dwelling units on that same property. Is that right?
Yes.
Okay.
My client was going to originally build one back there, but when he was going through the purchase price of the property, they presented the facts of this BZA zoning, that this was, the zoning did call for with the MUN zoning that he could build the two properties. And then with the setback, he already had the past BZA approval of the setbacks. Had already been passed once. It just expired. He just needed to go back through the zoning process, or the BZA process.
Okay, thank you.
Elizabeth, do you have it?
Yes, I actually should have made some remarks about the history of this case, because first I wanted to, bring forth to the board's attention that this has been recommended for disapproval by the planning department. So there's a memo in there recommending disapproval. The parcel was rezoned. I would have to look at the year. I can look at that. I think it was around 2000, because it was being used as a hair salon. So it's on a residential street. It was rezoned, spot zoned to MUN. They did file an application a few years ago requesting, it's in the board's packet, the order. There's not a lot of information there, but at any rate, that has been approved. That did expire, and I would, submit that we don't have the facts that were before the board then, before us now.
Well, and also, how did it pass? Because, looks like there were 4 people here. There were 3 people missing, 4 people. Okay. I saw 2 names. I thought, how did it pass with 2 votes? But I see.
Yeah, I don't do the orders that way now. I go ahead and just put the person who first and seconded in the ayes.
Okay.
Shrinking it down.
Any further questions for the applicant? Okay, you've got some time left on rebuttal, so after the opposition speaks, you've got time to speak.
My name's Timothy Brown. I live at 5303A Kentucky Avenue in the Nations. Some background on this. The person who sold the house to his guy was the former chairman of the Planning and Zoning Committee for the Nations Neighborhood Association. And I do remember when he went through the process to get the additional building in the back, but it was just one. I don't truly oppose this, but it was just one building rather than two. I don't know where they're going to park the number one house.
Well, now the order that we've got in our package for 2019 said it was approved for a special exception to reduce the street setback in order to construct 2 residential units.
Was it that? Okay, so
That's what it said.
if there has been no change since that previous one, then there really isn't any opposition except that it hadn't come past the Nations Association Planning and Zoning Committee as a new project, so we didn't realize the whole scope of this particular application. So,
So are you here, did you say you're here for a community organization or an HOA or?
It's a community organization. It's not an HOA, and it's simply that the Nations Association Planning and Zoning Committee asks that developers and people seeking variances come before us to let us know what they want to do and seek whether we support it or not. And in this case, if I remember correctly, we had no opposition to the original BZA, but now that I understand what the situation is, I happen to be here for another case, so I just thought I would speak on it. So I'll withdraw opposition based on it hasn't changed from the previous one.
Okay. All righty. Thank you, sir. Do you have anything else you want to address?
So I didn't know you guys had an association when we were.
Okay. All right, we'll close the public hearing and discuss. I don't know whether last time around that we had planning's disapproval on this or not. I don't think it's, I mean, I get that the applicant, it is very logical to think it's been approved once, but I mean, these things do, time changes things. We get different things in the package. I don't know whether there was a disapproval last time from planning or not. And, it is a special exception, so there'd have to be some deleterious effect to the neighborhood, and planning says there is, that it confuses it doesn't align with it confuses the public and private realms, but then, the opposition has been withdrawn, so, help me out here, somebody.
Ms. Waits, is this one of those? I know we have several here in the nations where there's a kind of as was referenced for the Belmont Boulevard one earlier, where there is a very large right-of-way that's kind of.
No, those are actually in the original part of the West Nashville plan that kind of go up to Michigan, and this is actually like further back, closer to the river.
Okay.
So there's not an issue with the right-of-way over here that I'm aware of. This is one of the special exceptions that, in my view, is more discretionary, because the ones that are set forth, there are the kinds that to reduce either a setback regulation or the height regulations, there's sort of a different kind of landscape with how you're supposed to weigh the factors. And so, of course, you would still look at all of your standard special exception factors, and then also the applicant shall provide evidence that the proposed building setbacks shall not create an adverse impact on adjacent properties nor detract from a strong pedestrian-friendly environment. So obviously it's just different than whenever it's one of the ones that's set forth in the zoning table that tells us exactly what the factors are in the zoning code to be able to obtain a special exception. The ones for height regulations and setback regulations are obviously a lot more fact dependent, like this one.
Did the applicant have a meeting, a neighborhood meeting? You did? Okay.
Well, I mean, it's also
from the neighborhood association. We have a neighborhood.
Okay. So, and also just an observation here that I think you could put one residential unit on here and comply with the setback. I mean, this does seem to be a case where they're putting 2 residential units where they could put one and comply.
This is a question I think maybe for Ms. Waits. Would planning have received and had the opportunity to make a recommendation one way or the other at the time this exception was originally considered in 2019?
I would have to actually look at what the code said at that time to verify whether or not the provision that we refer all these types of special exceptions to the planning department. And then assuming that the code hasn't changed since then, I would also still have to speculate that we followed through with that process. So I don't know.
Going to ask the applicants a couple questions. Sure. My usuals. This is the first time today.
If you can come back up, yes, sir. And if you'll turn your light on.
Just that. And if you've been here before, you know that I go into the tree questions here because I'm looking at where you're putting some pads down, and it looks like you've got some fairly nice trees at each end around this. Don't want to lose the trees.
Right.
What have you taken into account to basically protect them? I mean, you start tearing stuff up and building back there, you might lose what appear to be some fairly nice trees.
I'm not sure that one tree in between the two houses is actually there anymore. No, yes, it is. Yeah, those two trees are there. Yeah. Those houses are so close together. He currently is Airbnb in the front house, so we're going to actually have to build a 6-foot wall in between the two houses, and I can make sure that tree is on the opposite side of that wall to protect that tree.
That would be a really, really good idea to make that a sort of, okay, thank you. I think we might put a condition in the approval.
Yeah, and so, I mean, you said that these are, I mean, because that was what a lot of the opposition came from, and not necessarily having the housing there, but having the Airbnbs there.
Right.
Can you talk to, how you might mitigate the concerns of, Airbnb guests in the neighborhood, parking, noise, things like that? Or have you had any complaints at your current, anything like that you can speak to?
No, I do know that we are going to have some balconies on the 55th Avenue side, which is facing directly into a commercial property, which won't affect the houses on I guess that would be 5501B. With the new building codes, how they make us do everything, I do spray foam all my interior walls and ceilings. So from a sound barrier standpoint, I don't see any issues with that, and they are going to be attached. He's got a pretty high-end Airbnb management company that's going to be managing these properties. Those will be pervious pavers in the back. There'll be 4 parking spots in the back. So it's not going to be anybody parking on 55th Avenue, which, as everyone knows, if you have Airbnbs, people don't normally have cars there anyways. But my partner has expressed interest in making sure that the appeal and the landscaping and everything is conducive to the neighborhood. The plans for those 2 houses attached, we tried to make them look as similar to the existing house as possible so it fits the neighborhood. They wanted to go up more floors than what was there, and I suggested against it because I didn't think planning would approve something like that, and it would stick out if they did go up. So he is aware of the neighborhood and the neighbors and keeping it, I guess, similar to all the surrounding houses.
Okay, we'll close the public hearing again and discuss.
I think the very last thing that he said, was important that he could comply with the current setbacks and create more intensity as far as the height of the units, and there's a concession on the setback to keep the units in line with some of the other the neighborhood around it.
Retain the trees.
And retain the trees.
Yeah, I'm good with that. I'm frankly pretty hesitant to do much more different than whatever happened with this in 2019 because...
And I've got a senior moment. I don't remember it.
Yeah, well, and I mean, I just I know, every lot is different, but this is a lot we've addressed previously. And, I think we have the planning disapproval. I appreciate their work and their review. But I'm concerned that they would have had the opportunity to comment on this in 2019 and didn't. And
I mean, to Ross's point, though, they could have, and last time they approved it, without us having it. I think sometimes time changes. It's probably different staff members, different people reviewed it.
Right.
This is a different board. So I think I will say, though, I think if that's your line of thinking, I think that's totally reasonable. And so, it's not that I had a strong disagreement. It's just...
Oh, no.
I'm stuck on it. So I think if we wanted to approve it for independent reasons, then I think I could go along with it. But I did what Mr. Pepper said really did strike a chord with me about how times do change, and how essentially we because the permit did expire, we get the opportunity to look at this again, and that's why planning weighed in again.
Yeah, and I can say that I wasn't here last time, so I was absent for the vote, but I would say I haven't been to the site. Planning has found that it is inconsistent with the policy, the T4NM policy, and it's a big ask. You're going from a 10-foot setback on a side street to 2 feet. I also think you could put one. It's an overbuild to me. I mean, you're trying to put 2 residences into a small space, and so you're encroaching into the, pretty substantially right next to the street. And I can't. Whatever happened last time happened, but I think you can do this with 1 residence and comply, and that's kind of where I am. But I understand everybody else's position on it too.
Well, I want my 2 trees. Or similars, if for no other reason. If it was a single unit, they could do it. Well, no, I'm just talking. We're not still open. So I mean, if it was a single unit, they could do exactly what they're, maybe shrink it down a little bit. But it is a big ask. It's a big ask.
Well, it's also, I think, as was noted, it is. I mean, it's not residential; it's MUN, and it is apparently across the street from commercial property. It's not like it's in the middle of the neighborhood, and it's going to be this really out of place thing. It doesn't seem like. And the representative from the neighborhood is here and doesn't have an issue with it. I mean, he would know better how it fits in with the neighborhood and what's going on there than we would, in that respect.
Questions of the applicant.
Well, yeah, I mean, those are good points. I think reasonable minds can differ on this one. That's for sure. I viewed the neighborhood representative as being more feeling like that if the neighborhood had committed before or their opposition was because they thought before it was just 1 unit and now it's 2, and that just didn't want to go back on a representation they'd made was what I kind of understood. But
I don't remember when the point was, so I can't say.
You can make a stab at it?
Well, somebody needs to make a stab at it.
I'll make a motion that we approve the special exception as presented. Because it meets the requirements laid out for a special exception.
With the proviso that the 2 trees indicated remain, or trees of similar caliber and type get stuck in there.
I will accept that.
Thank you, kind sir.
Yeah. Okay, motion. Is there a second?
That'd be second.
So there's a motion and a second. Any further discussion? All in favor, say aye. Aye. All opposed? No. Okay. So that doesn't have 4 votes, so that doesn't pass. So it comes back
in December.
Yes, sir, at the next meeting, which will be December 1st. So this matter will be heard again on December 1st. There won't be a public hearing. It'll be for the board to take a look at the video for the members who aren't present right now, if they have an opportunity to, and to let us know how they vote. So you're more than welcome to be present, but there won't be any testimony unless the board makes a motion to have some. So I hope that's clear. And then this matter will be back on our docket for December 1st here at the same location at 1 o'clock. Thanks.
Thank y'all.
Will be at early session or waiting the whole time?
It'll be closer to the front of the agenda because some newer cases that have been filed since. Yeah, I think I understand the question. Yeah.
Ms. Waits, can we ask that it's at the front of the docket?
Sure, yes.
Yeah. Okay. He's been here a while.
Hopefully next time we will not have to adjudicate a boundary line.
Will 136 be heard today? Will 136 be heard today?
Yes, he is.
Mr. Cuthbertson has left court and come to us.
So we'll call it that public hearing. It's just going to take me just a minute to find my slides
so
on that.
136. Does anybody need to take a break before we go to 136? Soldier on. Okay, no break. Okay, so we'll go to 136, I guess.
I spoke up Michigan Avenue in that last hearing. All right, 2022-136 is a request for a variance from the minimum lot coverage requirements to allow construction of a two-family development at 4801 Michigan Avenue, zoned R6. Here's the zoning map of the area, and so you can see it's sort of I'm not going to call it a double lot, but it's a slightly, different configuration than the other lots along this row. And then our aerial view of the Nations. This is the subject parcel, which is vacant, and then it's there at the corner. I went ahead and included just some info and a map of the contextual overlay that obviously is kind of the ordinance that triggered the need or the desire for the request for the variance. Here is the site plan that's been submitted, and then we've got notations reminding us that the minimum lot coverage permitted by code would be 2,123 feet, and the request is around 2,700. This is some information about contextual overlay that was submitted by the applicant, and the numbers are the same as the ones that were verified by our zoning examiner. And that's my last slide. I just left that in there since I thought it was a graphic that I saw from the applicant's application, and you may make your presentation.
Before I introduce myself, what I'll say is to all the attorneys who sit on this board, I have sincere appreciation for what you do. Sitting in court all day long, I don't understand how you volunteer to do that. It's quite exhausting. I'm over. I'm through it. So Dwayne Cuthbertson, 409 Merritt Avenue. I'm here on behalf of the property owner of 4801 Michigan Avenue. We are requesting a variance of the maximum building coverage. The maximum building coverage standard that's found in the contextual overlay is actually what we're asking for relief from. And it is to permit two fairly standard residential dwellings on this combined property. The property itself is 9,000 square feet. As you can see, this contextual it's kind of a unique situation where we've got a contextual overlay that applies to one block in this neighborhood. It applies to this block faced and the one on the opposite side of Michigan Avenue. That's it. That's all it applies to in this neighborhood. And so the intent of a contextual overlay is really to preserve an existing character or built pattern within its boundaries. So the intent was to preserve the built pattern of this block when it was applied in 2014. The building pattern in 2014 did not look like that. I think I provided an older aerial that showed something that was closer to what the block looked like when this overlay went into place. But as you can see, these lots were parceled out, and individually they were developed, and the building pattern looks very different now. Nonetheless, the contextual overlay still applies. And it's weird the way it's applied. So we're limited to 150% of the building coverage of the two lots adjacent to us. So we're a 60-foot wide lot, and we have to take the building coverage of the two 25-foot lots immediately adjacent to us. And building coverage is defined as just the primary house. Well, those two 25-foot lots next to us have shotgun houses, but they also have detached garages or carports, whatever they are. They're developed out pretty intensely. So still, if you take it per lot and multiply it by 150%, we're at 2,100 square feet. Well, that 2,100 square feet applies to our 60-foot, 9,000 square foot lot still. There's no proportionality there. So even though our lot is more than twice the size of those 25-foot lots, we're still limited to 2,100 square feet. So we're asking for a variance of that so that we can build, again, two reasonably sized houses on this combined lot, the corner lot. What we want to build is pretty compatible with the other corner lot on this block, and in fact, one of the corner lots on the north side of this block, and in fact, compatible with very many double lots in this neighborhood. We're asking for the variance to allow us to build two-story houses on this property, a front to back. The building coverage that we're asking for is 2,706 square feet. The standard that we are required to hit, 2,100, is 56% of those 25-foot lots. The 2,700 square feet that we're asking for is only 30% of our combined lot. So I would submit that what we're asking for, in fact, is actually much less intense than the pattern that's found in this contextual overlay. So it's very weird and hard to articulate, at least for me in my mental state right now, but we're asking for relief that's actually less intense than what exists on this block pattern, other than the building coverage. And I would also say, if we jumbled up our proposal and detached our garages, we might actually be able to hit that 2,100, but then we'd have detached garages included, and it would just look like a mess, and the overall effect, I think, would be much more intense looking. So other than this building coverage request, we're complying with the height standard in the contextual overlay. We're complying with all other standards of that contextual overlay, but also the R6 zoning requirements, including the landscape ordinance. Unfortunately, this lot is bereft of trees, so anything we do, we're going to have to make some plantings and improve it. We'll also maintain the sidewalks that are there. So with that, I'll rest and ask for your approval on this request. Thank you.
Any questions for Mr. Cuthbertson? Okay, well, is there opposition?
Do you want to just sit here?
Sure.
Again, Timothy Brown, 5303A Kentucky Avenue in the Nations. And although I'm a member of the Planning and Zoning Committee, this has not appeared before our committee, and I don't represent them in this case. I'm actually here on behalf of a resident who lives along that contextual overlay who couldn't make it, but I volunteered to come down. The way the request is written, and I was not fully aware of the plans that they have for these houses, and it doesn't look too different than the other end of the block. My only concerns then become the existing sidewalks, I don't believe are to current code and would need to be replaced, and I don't know how that impacts their plan. He mentioned that the height of the buildings meets the contextual overlay, so for that purpose I have no concern. And if it's simply the the percentage space as it's requested here, he does make an interesting case, and the only thing I can say is I don't know how the contextual overlays work in terms of how strict they have to be interpreted. In this particular case, I just don't have the experience to say, we would oppose it if it had been brought before our committee or not, and so therefore I leave it up to the wording of the contextual overlay and how it's interpreted by the board, but on the condition that sidewalks be replaced with current code sidewalks and tree requirements to code. I can't think of other issues. The owner of the property bought it after the contextual overlay went in, so he should have been aware of all this. But again, it doesn't seem totally unreasonable, but I can't speak for how the CO is written. Questions?
So is it fair to say you're not in opposition to it, but you would like the sidewalks built, and we don't have any say on the sidewalks?
No, they should be replaced to code is my understanding of any new construction. They would have to be, unless they requested a sidewalks variance. I don't believe they get approved for in lieu of any more.
But you don't have any opposition, fair to say?
I can't say that I oppose it only from the standpoint of it's not the way the contextual overlay is written, and on behalf of the person who asked me to sit in for them, they'd be sticklers about it. But
okay, I'm asking because if you did, then we need to give him a rebuttal.
No, I would welcome his any additional comments. So
we won't treat that as opposition. Then.
Okay.
So we'll close the public hearing unless any.
Can I ask Mr. Cuthbertson? I'm assuming this is what the code says, but you're planning on building sidewalks because it doesn't look like there's existing sidewalks on the property.
Oh, there are.
Oh, there are.
On both frontages.
On both frontages. So you'll be replacing those on both frontages.
We'll have to comply with the sidewalk requirement, and
I see.
I have dimensions here, and the grass strip is not wide enough, so that will have to be wide.
Okay, so that's part of it. Okay,
we'll close the public hearing and discuss.
Well, I feel pretty persuaded on this one. Interestingly, I was looking at section 17.40.370 because I wasn't sure if exceptional width was in there, but it says exceptional narrowness, shallowness, or shape. And so I'm persuaded, and I'll go ahead and make a motion that we approve the variance as requested due to the shape. This was a special exception.
No, it's a variance.
Is it a variance?
It's
okay.
Variance. So you'll make a motion to approve it essentially based on the
based on the shape of the lot.
And I'll second that.
And he's putting trees, so I'm happy.
Any further discussion? All in favor, say aye. Aye. Any opposed? One opposed. Okay, so that passes 4-1. Thank y'all. So we've got one more case to deal with, which is...
Yes, sir. There's just one final matter on the board's agenda today. We've got case... There's one remaining item.
2021-146 we have to deal with. So here's what members of the board, we heard a case which was, I think it was a 2019 case, or 2020, even though it's coming back to us, or maybe it was this year. At any rate, it was the case involving the height plane, the height and control sky plane provision and the Green Hills Urban Division overlay, and the board voted to uphold. It was an item A appeal. The board voted to uphold the decision of the zoning administrator. The Chancery Court, Chancellor Perkins has sent us an order saying he reverses the decision of the Board of Zoning Appeals and remanded it to us. So I will, based on that, I will make a motion to at reversed. And I think it's incumbent upon us at this point to find that the zoning administrator erred. That's my view of this order. If anybody disagrees, tell me why.
I haven't seen the order.
Okay, well, it was in our packet. We've got
I'm sorry, and it was in the packet, but I'd be happy to read the full conclusion section. It's only one paragraph from the Chancery Court. By providing height requirements that differ from base zoning, the design guidelines supplant the base zoning height requirements. See Green Hills Neighborhood Association 2015 Westlaw 3977, page 6. Accordingly, the court hereby reverses the decision of the Board of Zoning Appeals and remands this matter to the Board of Zoning Appeals with instructions to apply the design guidelines height controls to the Stoltz project. Costs of this cause are taxed to the respondent, Metropolitan Government of Nashville and Davidson County, acting by and through the Board of Zoning Appeals, for which execution may issue if necessary. It is so ordered. Chancellor Perkins. And, basically we've received an order, and I agree with Mr. Pepper, pretty clearly indicates that the board's being reversed and that the case was remanded back to the board to do the opposite.
I think this is the judge views this as a ministerial requirement on our part that procedurally we should find that the zoning administrator erred, and the court, which I view as having authority over this board, for sure, has directed us to do that. So,
with all due respect, Mr. Chairman, I mean, the court can say, all right, we erred, and I am finding we did wrong, but I don't think it's within the purview of the Chancery Court or any judge to require us to agree with them. And that's how I'm looking at it. And if Russell wants to fuss at me for that, he can. But that's, sorry, Metro. There are enough votes that it doesn't matter which way I go. So it's just a philosophical difference that I have.
Only if.
Well, if anybody else agrees with me, and I don't think I've convinced any of the lawyers up here right now.
Well, I will state I am not going to participate in this vote because I was not on the board at the time it was decided.
Oh.
Can may I speak?
Sure, absolutely.
So first of all, before this goes too off the rails, so the order of the chancellor is simply that the administrator erred in applying a rear plane. And so it's simply you have to use the height controls that exist within the UZO. So I think first of all, to your point, I think you're capable of voting on this because the question is coming as to whether or not you're simply applying the design guidelines, the UZO guidelines, as opposed to base zoning rear setback. So I think you're eligible to vote on this. I want to clarify that point. And also, I agree with the chair's position that this is ministerial. Once the UZO's height controls, and there's no question that the underlying base zoning rear control isn't in effect, then I don't think that there's any room for debate on this issue.
Do we know what the vote was last time we came through?
Yeah. Yes, I have the order in front of me.
There were four voting in favor of to uphold the zoning administrator, Ms. Carpenter, Mr. Lawless, Mr. Newton, Mr. Cole, and Mr. Taylor. Actually, there were five. There were two against, which were Ms. Davis and myself.
Hey, you gonna vote?
I'm not.
Well, I mean, then we're not going to have the.
No, I'll relent.
Okay. I remember this case, and I remember feeling very strongly when I voted aye. So, but it sounds like we don't really have an option here to vote otherwise.
Well, I think we've got an option. It's just I don't like directions from courts like that, and having sent and had mine rammed back at me a few times too by people above it. I'm going to go with it this time.
Okay, and I understand that, but I will say, to take it context, I mean, the Court of Appeals of Tennessee reverses trial courts all the time and directs them that to enter or do this or do that. So I view this as within the purview of the court. And I think the judge is asking us to do something or directing us to do something purely ministerial. So, but I appreciate your
I'm more of a contrarian on that.
I appreciate your wanting to maintain the independence of this board, Mr. Wallace. I appreciate that. We will never get run over. We will never get run over with you on the board. I get that. So I will make a motion that we find that in this case the zoning administrator erred.
And I second it.
Okay. All in favor?
You're just doing what you did last time. Reluctant.
Okay.
Reluctant.
We have 4 votes in favor. So there we go.
Motion to adjourn.
Second.
Third.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.